Tennessee is now open for the transaction of business. All those having business before the court draw near, give attention, and you shall be heard. The Honorable Chancellor Michael Mansfield, Judge Burke, and Judge Rice presiding. Be seated and come to order.
Good morning, everybody. Good morning, Your Honor. All right. Hope y'all had a good trip into Jackson, Tennessee today. Glad to see you over here in West Tennessee. Judge Burke, Judge Rice, good to have you here as well.
Thank you.
Everybody's traveling. Everybody traveling. All right, good deal. Any preliminary matters we need to take up or discuss before we start the motion hearing?
Your Honor, the parties have discussed beforehand. We have a little suggestion, if your honors would indulge us in terms of the order of things this morning. Thought it might be helpful if we segregate argument a little bit and have a discussion of the merits first, with Mr. Harris taking the first spin on the argument there, given his motion for summary judgment on that, and back and forth as much as your honors like there, and then address some of the procedural issues sort of secondary, so it doesn't get all mixed in with the discussion of merits as a follow-up to the merits conversation whenever your honors have exhausted that issue. I'll take the first spin on that particular presentation with Mr. Harris to have response and as many rounds thereafter as your honors desire.
All right, Mr. Harris, is that good with you?
Yes, Your Honor. We discussed that last week in full agreement. Okay,
well, that sounds good. Well, that took care of the preliminary issue we were about to discuss then. We were going to figure out the order of getting all this done. So I'm glad you guys have that ready. Judges, you have any issue with that?
No, that sounds good.
Okay, so that'll be just fine. So Mr. Harris will give you the first shot at the merits, then we'll go as far as we need to exhaust that, and then Mr. Brandon will give you the shot at the procedural issues and exhaust that issue, all right?
Thank you, Your Honor.
Good deal.
And if your honor would just indulge me one more time.
No problem.
Mr. Groves is joining me today, my colleague. You've seen his name on filings, but he hasn't had the pleasure of being here in Trenton or down in Jackson today, so I just wanted to introduce him. He's an assistant attorney general with our criminal appeals division. So this courthouse is familiar to him, but the Chancery Court is not. So
Good deal. Glad to have you, Mr. Groves.
thank you.
Yeah. All right. Mr. Harris, you ready to go?
Yes, Your Honor. Good morning, judges. John Harris, representing the plaintiffs in this matter. As just discussed, we've sort of broken up the oral arguments to try to focus on discrete issues that are before the court today, and I'll be taking the lead on the merits arguments regarding essentially the application of the constitutional doctrines in Bruin. Based on the court's prior rulings, on the merits aspect of the case, we're here on a very limited topic today, and that is the question of a declaratory ruling as to the constitutionality of two specific statutes in Tennessee. The question becomes whether under the Tennessee Constitution, Article 1, Section 26, either of these statutes can survive a challenge constitutionally based on Tennessee's constitutional clause, as that clause is limited by holdings of the U.S. Supreme Court. The two statutes at issue have to do with carrying firearms with the intent to go armed. One is a statute that relates to citizens who desire to carry in public parks, greenways, and other items that are described by the statute as recreational facilities statewide. The other is a broader statute, 3917-1307, and we're only talking about subpart A in this case. The remaining parts of that statute are not being challenged. Subpart A says that it's an offense to carry with the intent to go armed a firearm or a club. The court may recall generally that in the past that statute also included knives. That was amended out because of constitutional concerns years ago by the General Assembly. My recollection is it was Senator Mike Bell that carried that amendment, but it was repealed out because of the constitutional concern. The original defendants in this case were Governor Lee in his official capacity and Attorney General Scometti. They were named because we were seeking declaratory relief And our review of the case laws indicated and the statutory provisions that to get declaratory and at the time injunctive relief against the state, you had to name some public official in an official capacity. The court took that issue up back in August of '23 and found they were proper parties. But in an abundance of caution, we did file a first amended complaint that named 2 state commissioners, the Department of Safety and the Department of Environment and Conservation, because of the law enforcement officers that those agencies oversee, as well as the sheriff for Gibson County and the district attorney serving that region. There have been no objections raised to standing or the inclusion of these claims proceeding against anybody as a defendant, with the exception of Governor Lee and Attorney General Scammetti. That'll be taken up later. One of the guiding concepts that brings us this type of litigation is the Supreme Court's repeated observations stated, for example, in Miranda versus Arizona in 1966, that where no rulemaking or legislation which would abrogate them. That is essentially the issue that we're looking at today. Does either of these 2 statutes, as applied or as written, infringe or abrogate a constitutionally protected right in Tennessee? As I've mentioned, we're only seeking a declaratory ruling as to those 2 statutes, and again, with respect to one of them, only part of the statute.
So you mentioned something that I want to clarify just quickly. You said as applied or as written. So is it clear to you, are you intending to raise a facial challenge as well as an as applied challenge to both of these statutes?
This case was filed predominantly as a facial challenge, Your Honor. Okay. An as applied challenge might be appropriate as to the individual named parties, but we believe, given the context and the ruling in Bruin, that a facial challenge is the preferred method, because to declare under the limited facts of the case either statute in an as applied context would have no distinguishing facts that would preclude it from being applied generally to all 7 million Tennesseans.
Understand.
The case is here before a 3-judge panel. I don't think that fact has been contested anywhere at all. It is here because in 2021, the state enacted this new act. It has a peculiar impact in that it places at the trial court level the burden on 3 panel judges to resolve a matter. Here, that the court's already taken that issue up when we looked at the injunction issue, and has determined that although, because it's in a chancery filing, the court may not have injunctive powers, but it certainly has the authority to issue a declaratory ruling. Again, that may be a topic brought up later in the later portions of the argument. We believe that declaratory relief in this action is appropriate under either of 2 provisions. One is Tennessee Code Annotated 1-3-121. That's a relatively new statute, has very little case law under it. It was carried by House member Glenn Cassida a few years ago, and essentially what it says is that any affected party can challenge the constitutionality of state action. Here, we believe the governmental action at issue is the enactment of the 2 statutes, as well as the court's, the state's enforcement of either of the 2 statutes, which, particularly with respect to 1307, we believe has been widespread. The second statute that makes declaratory relief permissible and appropriate is 29-14-102. Both of those are discussed more fully in our brief, and I really don't think that's even been questioned in terms of, absent the jurisdictional issue, whether or not declaratory relief is available. We do not believe that there are any material facts, therefore summary judgment is appropriate at this stage. And we believe also that as discussed more fully in the briefing between the parties, that the plaintiffs have standing. As indicated earlier, the only standing arguments, or the only arguments phrased in terms of standing, have been those raised by Governor Lee and Attorney General Scarametti. But when you look at it, those aren't really standing arguments in the typical context of the plaintiff lacks the capacity to bring the claim. It's really a question of whether or not they're proper parties, and we'll take that up later. But other than that, I do not believe there's any issue about standing of any of the plaintiffs to bring the claims, particularly as to the other co-defendants. Now, given the fact that I'm going to be, at some point this morning, getting into the analysis under Bruin and Heller and Rahimi, the question really that all three of those give rise to is, do the challenged statutes and the statutory scheme that they embody, do they seek to regulate conduct that is constitutionally protected under either the Second Amendment or the Tennessee State Constitutional Clause? Because of that, I think it's critical to put a proper perspective on what these statutory schemes do and how they function. And I would note that I think there is substantial disagreement between the parties, at least based on their briefing, as to what the Tennessee statutory scheme is. And part of that, because of the way Bruin, Rahimi, and Heller work, calls upon this court to make a determination as to what this statutory scheme is, and does it implicate Bruin's prong one, actually Bruin's only prong of does it fall under the scope of the Second Amendment. So let's talk about the two statutes. The first one I want to examine the statutory scheme on is the Parks statute, 3917, 1311. 1311 makes it an offense to carry firearms in certain areas that are owned, used, or maintained by the government for recreational purposes. There's an enumeration list in the statute, such as parks, greenways, et cetera, but ultimately the descriptive term that the statute has is for recreational purposes. So these are not government buildings, they're not jails, they're not high security areas, these are recreational facilities as described by the General Assembly. It's also, I think, important to understand that when you look at 1311A, the crime that is discussed is carrying a certain class of weapons with the intent to go armed in these locations. That is, the state under 1311 is defining a gun-free zone. Under the terms of, or the analysis sometimes you see in Bruin, for example, and even in Heller, this would be sort of a sensitive places type of statute. But I think there's aspects of this statute that warrant consideration and understanding. The statute itself, when you look at 1311A, is restrictive to only certain types of weapons. The statute specifically says it's an offense to carry, whether openly or concealed, with the intent to go armed, and here's the phrase, any weapon prohibited by 3917, 1302A. 1302A is significant because it enumerates specific categories or types of weapons. These include explosives, devices principally designed or made or adapted to delivering or shooting an explosive, machine guns. There was category 4, which was deleted in 2022, but the court may recall that that category included short barrel rifles and short barrel shotguns, hoax devices, knuckles, and any other implement for the infliction of serious bodily injury that has no common lawful purpose. It's noteworthy when you look at 1302A that the list does not include any category of weapon that we would ordinarily classify as handguns, rifles, pistols, or shotguns. Indeed, the only firearm that's listed anywhere in 1302A is in Category 3, the machine gun. Everything else is not typically classified or understood by the public as a firearm. Now, you might note, but I'm sure the court has run into this in other cases, that the heading on the statute is broader than the body of the statute itself. And I would point out that whatever heading is added to a statute, unless it's expressly contained in the language enacted by the General Assembly, is a descriptive term added by the Codes Commission. Those come in under Title 1-1, 105 through 111, and case law in Tennessee is clear, for example, Moore versus State, that those titles, even those code sections that the Code Commission adds, are not to be used to interpret the scope of the statute. Therefore, aid in finding provisions of the statute, but the inclusion by the Codes Commission of the term weapons in the caption, in the heading of the statute, doesn't override the restriction in 1311A that it only applies to 1302A weapons. Unfortunately, part of the reason we're here, and this is addressed in our complaint and in our pleadings, is the Attorney General's office, at least as early as 1996, has rendered opinions that this particular statute, 1311, is not limited to 1302A weapons. The Attorney General's office has opined in at least a couple of AG's opinions that the Parks statute covers not only 1302A weapons, but it applies to any firearm. Now, I would submit that the Attorney General's office has misinterpreted the statute, and I want to explain why. First, 1311A is quite clear. It's only weapons under 1302A. It appears in the Attorney General's opinions that the AG's office has looked at Part B of 1311 and noted that there are a number of circumstances under which individuals might, depending on the facts, not be subject to prosecution under 1311A. Those include, most notably, a series of categories of individuals who, based on their jobs, if possessing a firearm in a park, in the official scope of their duties, would not be subject to prosecution. Under Subpart B, however, in I think 2008 legislation carried by Senator Beavers, the General Assembly amended the statute at that time, in part because of these Attorney General's opinions, to make clear that, or to say that, a handgun permit holder possessing a handgun in a public park would not be subject to prosecution. The problem and the need for that clarification was not to include normal firearms within the scope of 1311A. And the reason is, when you look at the language in B that says permit holders would have a defense, one of the types of firearms that is in fact listed under 1302A is the machine gun. But in Tennessee, permit holders are allowed to carry, if you have the permit, any handgun. There are at least 40 that I'm aware of types of handguns which are classified as machine guns. Some common examples that civilians can legally own are the MAC-10, the MAC-11, the Uzi pistol, the Uzi handgun, the Beretta 93R. All of these are fully automatic handguns. So the scope of 1311A could already include a specific category of firearm, the machine gun that constitutes a pistol, And therefore, it was unnecessary for the Attorney General to take the exception that's contained in B for permit holders and try to expand it to include all firearms, when 1311A is clearly restricted to a specific statutory list of weapons. Tennessee has exhibited an unchallenged history of enforcing the park statute, including enforcing it against, or attempting to enforce it against individuals carrying handguns. We cite in our brief the case of State versus Erweling, E-W-E-R-I-L-I-N-G, as well as the case of Embody, which both parties discussed for various reasons. It's also notable that the Tennessee Pattern Jury Instruction Criminal 36.04 embodies the Attorney General's interpretation without questioning how they got to the expansive inclusion of all firearms and do not limit the application to just those in 1302A. Further, the Attorney General's office has not disclaimed its interpretation of the Parks statute to include all firearms. As I indicated, as early as 1996, in Opinion 96-80, the AGs concluded that the inclusion of firearms and the gun-free zone that 1311 creates does not violate the Tennessee Constitution. I would add, though, as we'll discuss shortly, at that time, the Supreme Court, the U.S. Supreme Court, had not decided the McDonald opinion, which came down in 2010, which forced the Second Amendment to be layered upon the Tennessee Constitutional Clause. And to the extent the Tennessee Constitutional Clause contains a phrase, regulate with the intent to prevent crime, that authority doesn't exist in the Second Amendment. So while the Tennessee Constitution, as we learned in the Rainwater decision just a few years ago, can provide protections greater than those contained in the Bill of Rights, it cannot provide for lesser protections. The broader statute that we're here to discuss is 1307A. A is essentially one sentence. A person commits an offense who carries with the intent to go armed, a firearm, or a club. The offense only has two elements: carrying of a firearm with the intent to go armed. The phrase intent to go armed is not defined in the statute, nor is it defined in the sections of the code relative to the criminal code like 3911-106, where we normally find definitions applicable to Part 13. There are other provisions of 1307 which we are not challenging, and this is important today. We're not challenging Subpart B, which makes it a crime for someone with a violent felony or a felony drug offense to possess a firearm. It does not challenge Subpart C, which makes it a felony for anyone who has a prior felony conviction that has not been pardoned, expunged, or restored to possess a handgun. We're not challenging D in this case, which makes it a crime to possess weapons with the intent to employ it, attempt to commit, or attempt to evade any dangerous offense as defined in 3917-1324. We're not challenging Part F, which makes it an offense to possess a firearm if the person has a domestic violence in order of protection or is otherwise prohibited by federal or state law from possessing firearms. Subparts H, I, and J, all relatively new additions to the statute, likewise create other possessory crimes. There are, however, two provisions of 1307 which also play a significant role today. These are subparts E and G, and we're not challenging these, but they're relevant to the discussion. E was added in 2014. It's called the Vehicle Transport Statute and basically says that it's an exception, and it's significant that they use that phrase. It's an exception that the person is transporting any firearm in a personal vehicle. Now, there's some conditions, but basically, it allows the transportation of firearms. That particular statute came about in sort of an interesting fashion because Speaker Nafee at the time was shocked to learn that riding around in rural Tipton County with a shotgun in his truck window was a crime. And so even not only the Republicans, but in a bipartisan effort, the defendants felt a need to at least let us transport firearms in our vehicles without a permit. Yeah, or boat, that's correct. Subpart G was added in 2021. Governor Lee called it constitutional carry. I want to make clear it is not. It is a permitless carry provision. It creates, again, an exception to prosecution under the statute. It has a number, depending on how you count it, as many as 7 conditions that must be met, such as age limits, where you're possessing, whether or not you have a prior stalking conviction, whether or not you've got prior DUI offenses. There's a number of exceptions, but generally, G creates an exception to the application of Subpart A. It's also significant that we look at and take a moment to see 3917, 1308. 1308 is a laundry list that starts off with, it's a defense. That phrase, term is particularly significant again to the application of 1307A that certain circumstances existed. So for example, defenses include you had an unloaded firearm, not concealed, and the ammunition was not in the immediate vicinity. It's a defense that a person has a carry permit under 1315, which we seldom see referenced, 1351 or 1366. It's a defense that the person possessed such a weapon at their place of residence, their business or premises, which would include, I assume, farmland, someplace you own but don't live on. That you possessed incident to lawful hunting, trapping, or fishing, sport shooting, or other lawful activity by a person possessing a rifle or a shotgun while in protection of livestock, by TVA officials, by state, county, or municipal judges or federal or county magistrates. From time to time, I have taught Tennessee firearms law to the Tennessee Judicial Commissioners Conference, and they are particularly interested in that subsection because it creates, and think about this, as I'm not making speculation, but I know judges across the state that on at least occasion wear firearms under their robes. And you don't think of that as a defense to a criminal act, but our statutory scheme makes it one. 1308B provides that these defenses are available to any offense under 1307 except for B1, which is the felony, violent felony or felony drug offender clause. Now, the state also brings up in the same sort of context another statute, 3917, 1322, that I want to just mention briefly, even though it's in their pleadings. 1322 is what I generally refer to as Tennessee's safe harbor statute. And it says that you can't be charged or convicted of illegal possession of a handgun if the fact that you were in illegal possession is discovered because you justifiably defended yourself or another in an attack, okay? The key is, in the context in which it was raised, is this safe harbor statute says you can't be charged or convicted. Now, it's interesting, I thought, that the state raised this argument because in other cases, it has made exactly the opposite argument. There's a case, for example, State versus Clark, decided in 2008, where an individual, I think out of perhaps Memphis, made the argument that because he had used the handgun in self-defense, that the indictment had to be dismissed because 1322 says I can't even be charged. The Court of Appeals basically said the statute makes no sense because you have to prove to implicate the statute that it was a self-defense event. And in the absence of that issue going to the jury, which is the only entity under our statutory scheme that evaluates the facts pertaining to defenses, that you never get to this roundabout. So essentially, the Court of Appeals read out of the statute as making no sense the you can't be charged clause. You can't be convicted if you can prove that illegal possession was discovered as a result of justifiable use in deadly force in self-defense. But the Court of Appeals said you can certainly be charged. Now, I want to turn, after talking briefly about the scope of these statutes, to the burden of proof issue, which I think is extremely relevant to the constitutional rights question. 3911-201 talks about the burden of proof in criminal cases. And the circuit judges on the panel, I'm sure, charge this frequently. You probably know it much better than I do, so excuse me if I am too elementary. But 3911-201 talks about the burden of proof in criminal cases. One thing it makes clear is that the state only has the duty to negate a defense. And I'm very particular in this part of my discussion with the phrases defenses and exceptions, because the statute is particular with respect to defenses and exceptions. The state has no burden to negate a defense unless admissible evidence is introduced supporting to the defense. Now, obviously, the state typically is not going to introduce admissible evidence supporting a defense. That's the burden of the defense counsel and the accused. And it's a burden that really only exists at trial. Then we have another statute or two statutes that I think are particularly key to this question of the constitutional right. 3911-202 defines the term that we've heard several times already this morning in the two challenge statutes. What is an exception? When the statutes talk about something being an exception, for example, using the phrase, it is an exception to the application of 1302A, 1307A, 1311. If it's an exception, then an exception must be proven by the person being accused by preponderance of the evidence. So exceptions, first off, are the burden of the accused to present at trial. Second, that burden never shifts to the state to negate it beyond a reasonable doubt. If it's an exception, the burden always stays on the accused. Now again, in a lot of instances that may seem okay, but we're talking particularly today about two statutes being challenged on constitutional grounds. Now, I think it's also significant that the state does not have to, with an exception, assert or allege in the charging instrument, this is in 3911-202A, B1, they don't have to allege that the exception has been negated. So they don't have to affirmatively show in the charging instrument that the exception doesn't apply. Then we have under 3911-203 defenses, or what does the term defense mean? And in a couple of instances, particularly 3917, 1308, all of those issues, that you possess the gun in your home, that you have it at your place of business, on your premises, that you have a permit, all of those are classified statutorily as defenses. When something is defined in a criminal act as a defense, the issue of the existence of the defense under 3911-203 must be carried by the accused in the proof at trial. There's also a part that will come up here shortly of the defenses statute that says in subpart E1, the ground of an offense, other than one negating the element of an offense that is not plainly labeled in accordance with this part, has the procedural and evidentiary consequences of a defense. That's going to have some relevance in a few minutes when we talk about the defenses to 1311, but it classifies all of those under 1311B as defenses as opposed to exceptions. Now, it's, I think, noteworthy that when we look at the statutory scheme, we have these exceptions and these defenses. Regardless of whether it's one or the other, there's no affirmative duty in the statutory scheme that an arresting or an investigating officer evaluate the strength. There's no affirmative duty that they evaluate the strength of an exception or a defense. They can exercise their discretion to do so. They have subjective authority to do so, but they're not required to do so. The district attorney, in evaluating whether or not to proceed with an indictment or a prosecution, is not affirmatively required to evaluate the strength of an exception or a defense. The grand jury, in deciding whether or not to indict, is not required to consider the strength of an exception or a defense. The circuit judge is not required to consider it unless the circuit judge is in a posture where the jury's been waived and they become the fact finder as well. It is only the fact finder at trial that is required under our statutory scheme to consider the strength of exceptions or defenses. Now, what does it mean to the average person on the street? It puts them at the kinds of risk that Bruin said is unconstitutional, and that is subjective authority of government officials. The crime in both 1307 and 1311A is carrying with the intent to go armed. Probable cause exists when an officer or even a civilian who decides to exercise citizen's arrest powers observes someone carrying a firearm with what appears to be the intent to go armed. That's it. Probable cause inquiry ends at that point. None of these issues come up. And once probable cause exists, what's the consequences to the citizen? They can be legally stopped, detained, questioned, searched, patted down, given a Miranda warning. They can be cited, they could be arrested, they can be charged, they can be taken in front of a magistrate and required to defend a case. All of those things are consequences of the application of the challenged statutes. And in each instance, both under 1307A and 1311A, the entire burden to demonstrate that the conduct that they've engaged in, that ostensibly is protected by the Tennessee Constitution as well as the Second Amendment, is not a criminal act by virtue of carrying the burden of either proving or persuading a jury that one of these numerous exceptions or defenses applies to them. Essentially, the statutory scheme in Tennessee eliminates the right that both the Tennessee Constitution and as a result of the layering on of the Second Amendment declare shall not be infringed. Now, when you look at that structure, it's hard to imagine any action, and none is stated in the defendant's pleadings clearly, any action that a citizen or an individual in Tennessee who wants to carry a firearm for self-defense can engage in, where that act can be done in exercise of a constitutionally protected right. Every instance imaginable is a criminal act in Tennessee, subject to one or more exceptions or defenses. There's no circumstance where you circumvent that. So the question lends itself, I think, quite clearly to declaratory rulings. Do these statutes survive constitutional scrutiny today? We bring the action ostensibly under Article 1, Section 26 of the Tennessee Constitution as it was enacted in 1870. There are two predecessor versions which are interesting but not necessarily relevant to that outcome. The first constitutional provision in 1796 in Tennessee was that the freemen of the state have a right to keep and to bear arms for their common defense. Note most specifically that that version did not contain the clause, but the legislature shall have the power by law to regulate the wearing of arms with a view to prevent crime, which was added in 1870. So in 1796, when we became a state, the freemen, ostensibly excluding the slave population, had a right. That was amended in 1835 to say that the free white men of the state had this right. But again, no regulatory clause. Following the enactment of the 14th Amendment, Tennessee amended its constitution, and we have what we have now, the 1870 version, which portends to give to the General Assembly the authority to regulate by law the wearing of arms with a view to prevent crime. In 1871, the Tennessee Supreme Court decided the Andrews case, which said, wait a minute, guys, you may have that authority, but you got to have a well-defined crime prevention purpose. You can't just throw that tag out there and pass constitutional scrutiny. There must be a well-defined crime prevention purpose. The Second Amendment, in contrast, however, we're all familiar, says a well-regulated militia being necessary to the security of the free state, a clause which Scalia discussed extensively in Heller and is not necessarily relevant at all to what we're talking about today. The right of the people to keep and bear arms shall not be infringed. There is no regulatory exception given to the government under the Second Amendment, and as we'll discuss momentarily, McDonald addresses that. I mentioned Heller, decided in 2008. McDonald becomes slightly significant, it becomes very significant, because McDonald versus City of Chicago decided in 2010, the U.S. Supreme Court said that by virtue of the 14th Amendment and the incorporation doctrine, we're going to force the restrictions contained in the Second Amendment upon all states, all local government entities. So no longer, even if it pretends to do so like Tennessee's Constitution does, grant regulatory authority to a governmental entity, McDonald says that grant of authority cannot exceed the shall not be infringed mandate of the Second Amendment. So we're back to a situation where the last part of that clause, which the defense in many of the cases it cites, relies on is that grant of regulatory authority. Now, for the last 15 years, has been declared essentially unconstitutional under the McDonald decision. We believe that the correct interpretation.
Hang on just a second, Mr. Harris. Officer, could you get this gentleman's phone, please, and take it outside the courtroom? Would you get that gentleman's phone and take it outside the courtroom, please? No, the phone. The phone keeps ringing. The phone keeps ringing. All right, go ahead, Mr. Harris.
Thank you, Your Honor. Defendants argue repeatedly in their pleadings that in a constitutional challenge, we start with the presumption, or Tennessee courts start with the presumption, that the law is unconstitutional and resolve every doubt in favor of the statute's constitutionality. And I think that's generally true as a propositional law. I don't think it's true because of the Bruin decision and the Rahimi decision, specifically in the context of evaluating constitutional challenges under the Second Amendment to statutory criminal enactments. And what's significant about that is when Justice Thomas writing the Bruin decision got to this particular point, the Supreme Court rejected what had been about 12 years of federal case law, where the federal appellate courts had developed a two-pronged test. And Bruin, quite clearly and unmistakably, and Rahimi doesn't change this, says there's only one prong to the constitutional challenge of a criminal statute. And that prong is the conduct.
Hang on just a second.
It might
So-
be your earbuds.
Okay. Yeah, somebody in here has a telephone, or there's somewhere that there's a phone going off.
I think it's his earbuds. The phone's ringing through his earbuds.
I tell you what, will your hearing aids still work if you turn the phone completely off?
I don't know, but go ahead, I'm very sorry.
Okay,
I got the phone turned off, and I just got those for Christmas, and it's,
okay, yeah.
we understand them every day.
All right, we're gonna try that. Take those outside and we'll see if that works, officer.
Does can everybody check your phones 3 times and make sure that they're off? Vibrators out, just turn them off.
Thank you, officer. All right, Mr. Harris, go ahead.
Bruin established an entirely new single-prong test. And that really just starts with the question of, does the conduct here, carrying with intent, fall within the scope of the Second Amendment? If it does, Bruin says the challenge statute is presumptively unconstitutional. That's one prong, that's the test that applies. At that point, under Bruin and Rahimi, the burden shifts to the state to demonstrate that the challenge statutes mirror or have an analog to some other regulation that existed in 1791 when the Second Amendment was adopted, such that there's a national historical tradition that can be identified to regulate that conduct at that time. If the state cannot carry that burden, the Bruin presumption of unconstitutionality prevails. Now, that is different than what the posture of review that the state urges upon the court, but I think it's quite clear from Bruin and from Rahimi that that's the posture we're in. Today, in this case, we apply a one-prong test. Is the conduct protected? Is the conduct within the scope of the protection? And if so, it's presumptively protected and the statute is unconstitutional. In Bruin, the court talks about, the Supreme Court's prior discussions about the scope of the right. Heller had said there's a personal right as opposed to the collective right. Heller also established that there was an absolute right to have these weapons in your home. Bruin expands that to public carry. But in each instance, what is being protected is this core right that the courts talk about of carrying with the intent to be armed, whether in the home or in public. That's what the two challenge statutes today overwhelmingly infringe. And the court makes clear that the only inquiry when we're talking about the state's burden is what was the public understanding of the scope of the right at the relevant time, 1791. The court also says that outside of that snapshot in time, whatever may have occurred prior to then in the colonial period or after that in, say, Reconstruction or the early 1900s and later, may confirm the understanding of whether or not there was a restriction in 1791, but it can't create new ones. The court makes clear that all history is not equal and that the most important part is to look at that window, noting that post-ratification, adoption or acceptance of laws that are inconsistent with the original meaning of the constitutional text cannot overcome or alter the text. That's Bruin at page 37. There's other parts of Bruin that I think fall within this analysis today. So, for example, the state talks much about the Parks statute and the need for, essentially public safety. That's where they're headed with that analysis. Bruin makes clear that collateral issues, which were relevant under the appellate court's two-pronged test, are no longer relevant today. So essentially, what Bruin tells us is, you look at that 1791 window to identify an analog or a restriction that existed, not just occasionally, but as part of the nation's historical tradition. The nation at that time was 13 states. To achieve a historical tradition, some significant number of that 13 must have had the same or similar rule. You can't just have one or two outliers, as we'll discuss in a few minutes. But it's critical that in evaluating the constitutionality of these statutes, we realize that the prior concept that existed when some of the cases that the defense relies upon of justification by public necessity, like public safety, is no longer relevant. If it didn't exist in the relevant nation's historical tradition, the fact that there may be a compelling need today, perceived or otherwise, is just insufficient.
And you're saying that because part two of that analysis is abrogated by Bruin?
Absolutely. Bruin, it specifically talks about the
Just go to
interest
part
balancing
Okay.
clause as being completely rejected, which was part two
Right.
of the analysis. As a matter of fact, one of the cases that the defense relies upon, which is the Embody appeal, which was a pro se appeal by a guy named Leonard Embody that got caught carrying an AK-47 pistol in a park in Nashville. He took that issue up, and Embody relies heavily on the two-pronged test analysis, which Bruin says is completely irrelevant at this point. Bruin also teaches us that this issue, sensitive places, is extremely, from a constitutional perspective, extremely rare. And it's not a tool to be used to find that a broader statute is unconstitutional. Sensitive places almost has to operate as a separate enactment. So, for example, we have statutes that are not challenged today that pretend to ban the possession of weapons in a building like this while court's in session, 3917, 1306. We have a statute that says you can't have, typically, firearms on school grounds, 3917, 1309. There are exceptions to both, but generally those are sensitive places that we're not challenging today. But those are separate standing statutes. Prosecutions under those statutes don't come up or shouldn't come up under 1307 or even 1311 because each of those sensitive places statutes, each of those sensitive places crimes have additional elements that don't exist in 1307A. 1307A has only got 2 elements, carry with intent. The courthouse statutes carry with intent or possess in a building, another element, when judicial proceedings are being conducted. It's separately prosecutable entirely. And so this reliance on sensitive places, Bruin says, you can't take the sensitive places doctrine and create restrictions, particularly broadly applicable restrictions, like banning possession in the entire state of Tennessee or in Manhattan, which was specifically referenced in Bruin. You can't use sensitive places to make broad bans constitutional, which is what the state's doing with both 1307A and 1311A. And quite clearly, Bruin addresses that and saying there might be sensitive places that can be added to the list that didn't exist in 1791. But Bruin says that those places would, as a practical matter, have to have been unimaginable by the founders in 1791 to justify them being added as a sensitive place today. And you'll find that at pages 30 and 31 of Bruin. Bruin talks about sensitive places, and then later courts have discussed, for example, that these sensitive places concepts, when you look back historically, and Bruin references in dicta, because no Supreme Court has made this finding yet, that such places might include, for example, schools. They might include, quite clearly, jails or prisons. Those have not been constitutionally vetted, but we're not challenging those today. We're challenging this, under these 2 statutes, the broad statewide application of a law saying you can't carry with intent. Our review of the case law and our review specifically of what existed, even though it's not our burden, in 1791 indicates that there were not sufficient states, if any, that made it a crime to carry with intent anywhere in the entire jurisdiction. Just didn't exist. There were not states that had laws, certainly rising to the level of a nation's historical tradition. Now, I'll give the defendants, they point out here and there that there's a couple of cities or a couple of communities here, there, or elsewhere that may have had local restrictions. There may have been some territories that had restrictions, but Bruin says those are not sufficient. Even an outlier state is not sufficient. You've got to have this, essentially a plurality of the states, maybe 7 of the original 13 that had a restriction sufficiently similar to say that restriction in particular, like you can't have a gun in your jail cell, was sufficiently adopted in a number of jurisdictions such that it constitutes a national historical tradition. But Bruin makes clear that isolated instances, occasional cases, territorial holdings, even the fact that one or more, a handful of states might have had it, doesn't satisfy the need or the burden on the state to prove the existence of a national historical tradition. Now, there's another concept that comes up in the Supreme Court cases. This one comes out of Heller, but it's repeated later. And it's the conclusion found in Heller that the concept of the Second Amendment and carrying firearms, the constitutional protection extends to both offensive and defensive carry. In fact, this was, I thought, an interesting observation in Heller. Scalia quotes Justice Ginsburg in writing that a most familiar meaning is, as the Constitution's Second Amendment indicates, wear, bear, or carry upon the person or in the clothing or in a pocket for the purpose of being armed and ready for offensive or defensive action, as in case of the conflict with another person. That's Justice Ginsburg. Now, in Heller, the court says, we think Ginsburg's accurate when she captured the natural meaning of bearing arms. And the court says, although the phrase implies that the carrying of weapons is for the purpose of offensive or defensive action, and then it goes on to say it doesn't necessarily require that you be participating in structured military activities, which was part of the decision in Heller, making it an individual right. But what's important is that, and we'll get to this in a moment, is that the scope of the right is to be able to carry in the event of conflict with another, whether that conflict be offensive or defensive. We do not believe that there are founding era analogies to Tennessee's 1307A, which is the statewide prohibition. Statewide prohibition. There is no part of the state of Tennessee that we can travel to where the carry with intent to go armed crime is not applicable. There's no place you can go. You can't go to your home. 1308 teaches that. You can't go to your business. You can't go to your personal properties. None of those places are exempt from the criminal charge that's potentially levied against you if you're found to be carrying with the intent to go armed. I mean, I grew up, it's not in the record, I grew up in East Nashville. I was young when I had the first episode to have someone pull a gun on me, but I jokingly, sometimes when I'm speaking on these issues to groups, talk about the fact that I come from a part of town where you wear a gun even if you're mowing your grass. And I didn't think that was a crime. I was on my own property. But it turns out that it is. And that's where we think this 1307A statute just goes too far, because it violates the problem that Bruin says is unconstitutional by making the entire jurisdiction or large portions of the jurisdiction gun-free zones. In this instance, the state relies heavily on the Tennessee Constitution's 1870 version clause regulating with a view to prevent crime. We think that's misplaced for a number of reasons. As I said earlier, McDonald, by applying the Second and the 14th Amendment to the states, has essentially rendered moot to the extent the regulate with a view clause exceeds the shall not be infringed mandate of the Second Amendment. It just can't exist constitutionally. Its vestige is there. There's a bill pending in the legislature, H.J.R. 53, to repeal that. They haven't done it yet. But it's a legacy, like an appendix. It's got no purpose anymore in our constitutional structure in the state. The reliance on the view to prevent crime clause in the state constitution ignores Bruin, and it relies heavily, as I mentioned earlier, on the Embody decision. And that's quite clear when you look at Embody. Embody starts off with, in the wake of the Heller and McDonald decisions, the Sixth Circuit adopted a two-pronged test for the Second Amendment challenges. And as you read down through the Embody decision, it is quite clear that they're applying that two-pronged test because they revert over to the intermediate scrutiny and the justification clauses that Bruin said are in that second prong that no longer applies. You'll find that in the Westlaw citation at page 6, but here's what it says. As pointed out by the trial court in its order, some courts have found intermediate scrutiny to be appropriate in cases of this type where the core Second Amendment right has not been implicated. Intermediate scrutiny requires that the statute or legislation serve important governmental objectives and be substantially related to achieving those objectives. That is interest balancing, no doubt about it, which Bruin says you can't apply anymore. The court says, after our review of the applicable law, we find no historical or legal basis for Embody's contention that the state may not regulate the carrying of firearms. The opinion states, anchored in Andrews, longstanding Tennessee law is such that the legislature may regulate the carry of arms with an intent to prevent crime. A view to prevent crime could entail regulations that must be adhered to by the people without criminal backgrounds. The problem with the state's reliance on Embody as being a case that the plaintiffs completely ignored is that it has essentially been vacated by the Supreme Court's rulings in both McDonald and in Bruin. Now, the state, although Bruin says if the conduct is within the scope, it's presumptively constitutional, the state reverts back to the general case law that talks about on a facial challenge, you've got to be able to demonstrate.
You said if the conduct, it's presumptively constitutional.
If the conduct falls under the second, it's presumptively constitutional.
Okay.
Yeah, I think that's correct. I was thinking through if I misspoke, but Bruin is prong one. If the conduct in question, carrying with intent, falls within the broad scope of the second, then it's presumptively constitutional and the burden shifts to the state to prove the national historical tradition.
Okay.
I think that's correct.
Thank you.
Defendants go outside of that scope and they attack the facial challenge analysis that typically applies and would potentially apply here, but for the analytical structure that Bruin creates and that Rahimi even applied. So, for example, the state says that we fail the facial challenge issue if they can show, or if we fail to show, that there is any incidence where the statute can be applied constitutionally, okay? If you look at the examples they give, which is carrying unprotected weapons, felon in possession, carrying in a park, carrying for offensive purposes, if you look at those, keep in mind on the facial challenge issue, if you apply it, that the two statutes being challenged have only two elements. Well, 1307A has two elements, carry with intent. 1311A has carry with intent in a park, okay? A specific set of. Each of these other examples where the state argues 1307 or 1311 can be constitutionally applied all involve necessary, statutorily enumerated additional elements. And it takes them out of the quiver to argue that these are valid prosecutions of carry with intent, because each includes those additional elements. For example, felon in possession. We're not challenging subpart B. That's the felon in possession clause. The additional element is you got to have a felony conviction. Prohibited weapons. We're not challenging 1302A. 1302A makes it a crime to possess those weapons.
So let me ask you this. If the court were to grant summary judgment under 1307A, because it has two elements, not additional elements such as certain places or certain conditions of the carrier, how does that impact those other sections, subsections B through? Meaning, if you find that A is unconstitutional, would that affect any of those that you're not challenging?
No, we do not believe it so, Your Honor. Each of those, B through, I think, J, with the exceptions of E and G.
Right.
Each of those contain additional elements. Each of them.
They both contain the elements of subpart A, right? Elements 1 and 2 are identical, right?
Several of them are mere possession, have nothing to do with
Okay.
carry with intent.
Okay, so you think that if A is unconstitutional, it does not affect any of the other subparts?
No, Your Honor, we're not challenging any of the others. We're only looking at subpart A.
Thank you.
And on the facial challenge arguments that the defendants make, I think that's, and we had discussed it more in our responsive brief, but that's the brief summary, is that each of these examples that they proffer, where they say 1307A or 1311 could be constitutionally applied, all have separate statutes and separate elements. They can't identify a single situation where those two unique elements, carry with intent, can be constitutionally applied absent the inclusion of additional elements. Nor have they identified any that could be constitutionally applied where there aren't other statutes that are applicable. So, for example, I mentioned a moment ago that Heller says, quoting Ginsburg, Second Amendment includes offensive or defensive carry. One of the facial challenge elements the state asserts is that the statutes, both statutes, prevent or prohibit offensive purposes. I don't know how you get there, because if your intent is offensive or defensive carry, if your intent, Heller says that's protected. So what happens when you cross the line and you actually use that weapon that's constitutionally protected in an offensive matter? There's a separate statute. It could be charged as assault with a deadly weapon. It could be charged as a homicide. It's another crime. It's not this crime. And actually, that's part of the problem with this statutory structure, is we don't even have a good definition because of the omission of a statutory definition of what is the intent to go armed. When I talk about this to civilians in self-defense classes that I teach, I bring up a case from the 1800s in Tennessee, and I apologize because I can't recall the name of the Supreme Court's decision right now, but I can tell you the facts. I think it's one of the shortest Supreme Court decisions I've ever read because it's only about a paragraph. Went all the way to the Tennessee Supreme Court. The basic facts are a guy gets charged for carrying with the intent. The facts were that he had picked up a gun in a small community to give chase to a bear that was in the community. He got convicted. Goes to the Supreme Court, in a paragraph the Supreme Court says he wasn't carrying with intent. He had no intent to be armed. He was carrying, whatever you want to characterize it as, in defense of the community or something, but it's not the intent to go armed. The problem is we don't have a good definition for what that is. We've got smattering of hints throughout the cases of what it's not, but not a good definition of what it is. And that's part of the problem that triggers the Bruin Court's concern that it's entirely subjective on government officials to decide, when they decide whether to stop, arrest, detain, question, or charge, as to what constitutes that intent. It's too much latitude without an objective criteria to evaluate it. You got a homicide, you sort of know. He had a gun, he shot him, and he killed him. You got some objective facts. Now, intent may be an issue in there somewhere, but you've got more facts than what we've got here, particularly when you're talking about constitutionally protected activities. So as I indicate, when you look at the facial challenge argument, consider that issue of each of the examples that they proffer have additional elements that aren't under 1307A or 1311A. Each of those examples that they proffer are predominantly possession crimes. Felon in possession, felony drug offense in possession, domestic violence in possession. You possess a prohibited weapon under 1302A. You possessed a weapon in a prohibited place or a sensitive place. And then they also mention offensive carry, but again, Heller struck that down, but they don't address it. What we have here, and this is explored in more detail because I know I've been rambling on, I apologize for that. In the response brief, we take a look at the fact that the state's argument is if even a single person in the state could be prosecuted under the act, then it passes constitutional muster. The key to that argument is the inclusion of additional facts that constitute, in most instances, either a prohibited person status or a sensitive place establishment. And the state's differential analysis of that issue, I think, is exhibited by the state's voluntary settlement of the federal court Beeler decision. Now, it's in the record. Y'all may not have read it, but here's essentially what happened in Beeler. And I think they filed a copy of the settlement agreement in their pleadings on December 16th of 24, okay?
I've read it. Have you, Judge Burke, Judge Rice, I've written. Okay, we're familiar with the facts, so you can go ahead.
Okay, so Beeler's pretty straightforward. Tennessee passed permitless carry. Bruin has decided 3 individuals 18 to 20 years old sue in federal court for civil rights violations in East Tennessee. Case is defended. Scarametti becomes the attorney general. Case goes from hotly contested to settled quite quickly, and in March of 23, they settled the case. The settlement was on the theory that it's a violation of the 2nd and 14th Amendments for the state to deny handgun permits or the ability to carry under the permitless carry law to individuals 18 to 20 years old, okay? Pretty straightforward. They concede Second Amendment violations if they enforce that restriction. But think about it. If the state really clings to the argument that it's not a constitutional violation if even one person can be prosecuted, then think of the number of people that have come before you as circuit judges, or that you may know independently, who are in the age brackets of 18 to 20 who have felony convictions, who have other factors, domestic violence, that make them prohibited persons. Based on that, Beeler makes no sense to argue there that it's a civil rights and a constitutional violation, because they could have easily argued we can find at least one person in the state with a domestic violence in that age bracket. And it didn't happen. So I think the realistic point is, when you look at the Supreme Court, the Heller, the Bruin, the Rahimi, when you go back and look at McDonald, when you look at Andrews and Simpson, Tennessee cases, you can't negate a constitutional challenge to the application of a statute by identifying other unique fact circumstances that are only actionable, that are only criminal offenses because they include additional elements. The fact that they might also be prosecuted here, I don't think is sufficient to protect the constitutional challenge against the challenge statutes. Now, another issue that the defense raises that I want to touch on in this opening argument is they make the argument that the challenge to the Guns in Parks statute 1311 would invalidate the permitting law. I don't think that's accurate or true or even our intent. And there are many reasons why. For example, given the nation's structure at this point, my handgun permit issued by the state of Tennessee is recognized according to the Tennessee Department of Safety on its reciprocity page in about 38 states. That permit, independent of what it means carrying a gun in Tennessee, is valuable because the state has reciprocity agreements with most of the nation that allows me to carry in the bulk of the states. There's no reason to challenge the Permitting Act. The status of the permitting scheme, we think, is irrelevant. The fact that dicta in Bruin suggests that 40-something states have permitting schemes is just that, dicta. But to argue that challenging 1311 requires the invalidation of the permitting statute goes too far. Like I said, reciprocity is one issue. I'll give you a couple of others real quick. We have a statute, 3917-1309, concerning schools. That statute says that with respect to private schools, on which ostensibly guns are prohibited by statute, that private schools can opt out and let their teachers carry if they have a handgun permit. With respect to public colleges and universities under 1309, schools don't even have to opt out. The employees of the school can carry on campus if they have a handgun permit. Civilians with handgun permits have the ability under 1309 to store the guns in their vehicles while they're on school grounds. There's lots of things where the permit has independent value, and it's why we're not challenging it in this case. One of which we hope to see is that Tennessee will adopt a NICS exception for those who have permits. Many states have that, we don't, but it's possible under federal law for Tennessee to say in their statutes that permit holders, merely by demonstrating the permit to a federal firearms dealer, could buy the gun without further background checks. They haven't yet, they potentially could, but these are issues that make the argument of the defense that striking down 1311 necessitates striking down the permit system a complete erroneous argument. Now, I want to turn briefly to this issue of historical evidence broadly. When you look at Bruin did, as I've indicated in a couple of different instances, the historical analysis. But what's relevant here is, at this point, Bruin says, starts starting in its discussion around page 46, that it considered 3 states that had gun restrictions during the colonial era. What's relevant to this part of my argument is the court says, we doubt that 3 colonial regulations is sufficient to show a tradition of public carry regulation. So 3 states, not 3 territories, not 3 communities, but 3 states having a relevant rule is not sufficient. The court then goes on to look at 3 additional states. So we got a total of 6 that are being evaluated. The additional states that they considered, which they described as late 18th century and early 19th century statutes, include Virginia, 1786, Massachusetts, 1795, and Tennessee, 1801. And the court rejected all of those as relevant to the historical tradition analysis. And in each instance, with respect to Virginia, Massachusetts, and Tennessee, they rejected those alleged analogs based upon the fact that there was an additional element that made it a crime beyond carrying with the intent to go armed. And in each of those 3 cases, the additional element was what is variously described as carrying to the terror of the people. You see it referenced in different ways, but essentially, let me characterize it this way. It's a public assault. You're doing something by your conduct, not the mere carriage of the weapon, but something by your conduct, how you're carrying it, that reasonably created terror to third parties in the community. We're not talking about that here. Matter of fact, we've got a statute, the assault statute, that could be used if that's what's going on. But that's not what's going on. The other thing that I find particularly interesting about Bruin and its discussion of the state of Tennessee is that Bruin was critical of Tennessee beyond any other state. Now, I may be the outlier in the court today, but I listened to the oral arguments in Bruin, in part because I was one of the attorneys that did one of the amicus briefs in Bruin. And I don't remember the justice, but one of the justices asked the question of the attorneys arguing on behalf of the New York law. Give us an example. Give us some examples of states that have a long history of regulating public carry. The first state was Tennessee, proffered as a justification for upholding the laws in New York that the court then struck down. So what did Bruin say in its decision about Tennessee law? First, it noted the Supreme Court, Tennessee Supreme Court's case in Simpson in 1833. In Simpson, we had a statute that made it a crime to carry to the terror of the people. The Supreme Court found that it was the issue, the act of creating the affray or the public assault or the terror to the people that was the actionable crime that wasn't protected by the Second Amendment. But it noted that the mere arming of oneself with firearms in Tennessee's Constitution, Second Amendment analog, had completely otherwise abrogated the crime. The other thing that Bruin says about Tennessee is found at page 629. And the court says, finally, we agree that Tennessee's prohibition on carrying publicly or privately any belt or pocket pistol was, on its face, uniquely severe, quoting Heller. That said, when the Tennessee Supreme Court addressed the constitutionality of that substantially identical successor provision, citing the 1870 acts, the Tennessee Supreme Court read this language to permit the public carry of larger military-style pistols because any categorical prohibition on their carry would violate the constitutional right to keep arms. And that's citing Andrews. So what does that tell us again? First off, Tennessee's got a long history of oppressive violations of the Second Amendment, if the Second Amendment had applied all the way back to 1796. Second is, Andrews says, to the extent that the criminal act seeks to prohibit activity in which some actions might be prosecutable, the statute can still be unconstitutional. And it's that nuance that you find in Andrews that says the carriage of the military-grade weapon, the long revolver, as opposed to a pocket pistol, is constitutionally protected. So the argument that we see from the defendants of, if we can just find one example where it could be effective, flies in the face of even the 1871 Andrews decision. It's not as simple as the defendants portend. When you step back and you look at this, considering that the Supreme Court in Bruin looked at 6 different states and found none of them to create an analog, where all of them pretended to have some type of public carry restrictions, the court says they all implicate other factors. Where we are today is the state has the burden to show under either challenge statute that the mere fact of carrying with intent to be armed constituted a crime as of 1791. And what we submit should be a plurality of the states. And there's no such evidence in the record. I'm open to questions if you have any, otherwise I'll pass.
Judge Burke?
I think I've asked enough questions. I'm tracking with you on the issue of 1307A being just 2 elements, and I understand that argument. But tell me about 1311, which includes a 3rd element as to location, and why you believe that facially that's unconstitutional.
Facially unconstitutional, Bruin says presumptively it is, the burden shifts. We believe it's unconstitutional because it doesn't fall within what Bruin and Heller identified as a permissible sensitive place. Just like where
So your argument on 1311 is not that there is, it's not the same argument as to 1311 as is 1307, which is there's no place that you can go under 1307 where it does not apply.
Correct.
And it takes the 3rd element to make it constitutional under your analysis, if that area or location or a prior conviction or whatever is a disqualifying factor. But under 1311, your argument is solely that it's not a sensitive area.
That's the primary argument, Your Honor. You look at Tennessee, God bless us, most of East Tennessee is a public park.
Right.
Just is. I spend a lot of time in Big South Fork. Huge parts of the plateau are public parks. All over the state, we've got a tremendous amount of real estate that's a public park. For 1311 to survive, you've got carry with intent in a park or recreational, okay? The state carries the burden to demonstrate the majority of the states, plurality of the states, the nation's historical tradition as of 1791 was that people can't carry in those kinds of areas. It would have been unheard of in 1791 or 1796 when we became a state to tell the people traipsing across the state of Tennessee that, wait a minute, you can't have a gun in the Smoky Mountains or in the plateau or at Notches. Pick a part of the state. It was all rural at the time. But I think that's exactly it. They got to carry the burden. The state's got to carry the burden that to define public parks, greenways, campgrounds and recreational areas as a sensitive place in order to fit the Heller and Bruin decisions that say there are some exceptions, like schools,
Right.
then that's a heavy lift. And there's just not evidence that a significant number, much less a plurality of the 13 original states, had that kind of restriction. And therefore, you can't make it a sensitive place. And in fact, you can just look at Bruin. I mean, Bruin's talking about the entire state of New York.
Right.
But the court said you can't make Manhattan, as densely populated as it is, with as many people as it has, and with bad as its crime rate, you can't make it a sensitive place. And if that be the case, you certainly can't expand it to the Smoky Mountains or Big South Fork or pick a state park. You just can't go that far.
I guess this is my last question. So you indicated the operative date would be 1791. For this court to look through the lens of 1791 and its historical traditions, but is that time frame changed by the 14th Amendment's application to the Second Amendment?
No, if you read in Bruin, the court said the operative date 1791.
Okay.
Thomas does say that, but this is dicta, that the date of the adoption of the 14th, 1868, might play a role. That's not been any court's adopted holding. And what we do see in Bruin, and I think reaffirmed sort of in Rahimi, is that the principal date is 1791. That what happens later
Just affirms.
it can affirm or reaffirm what the law was in 1791 if it was a continuous, long-standing provision, but you can't take new acts that arose long after, including that period, and create new sensitive places or new restrictions arising at that point in time. It's got to reaffirm or confirm what existed in 1791. So I don't think that the date that was mentioned in dicta of 1868 and the 14th Amendment it gives us an either or, that it is a law that either existed in 1791 or one that existed in 1868, those eras. Whatever happened later has to, according to Thomas and Bruin, confirm or reaffirm the earlier tradition. And it can't be used to just create a new one that didn't previously exist.
Those are my questions, Chancellor.
Judge Rice?
I'm fine, thank you.
All right, a couple of questions, Mr. Harris. So with regard to the state's one example issue, that sounds like rational basis review to me. And I can't see, what's the basis, and it may be the rainwater case, I'll give you a hint that I think that may be it. What's the basis of them standing up here with a straight face and saying, in light of Bruin's one-step analysis, that now the state of Tennessee is allowed to apply what appears to be even rational basis review just because it's under the Tennessee state statute? Does that make sense?
Your Honor, I don't think it does.
I mean, does my question make sense? I know you don't think the whole scheme, but does my question make sense to you is what I'm
I
asking?
think I follow the question.
Okay.
I think what we're stuck with is strict scrutiny under the Bruin, Heller, Rahimi, McDonald standards. And the Bruin standard that says if the conduct is within the scope. And keep in mind that the courts have found the scope to be extremely broad. Ezel, for example, found the commercial operation of gun ranges against the city of Chicago to be within the scope.
But doesn't the one person or one example of constitutional application, isn't that rational basis? I mean, I understand it appears to me that Bruin is even a more heightened standard than strict scrutiny. You know, strict scrutiny requires the compelling state interest in a narrowly tailored remedy. And the state is saying, if we can find one example of this broad statute that is constitutional, then we have to find it constitutional. So Is it the rainwater decision that is allowing the state to say that essentially we use rational basis review in this besides Bruin? Or what authority do you have or do you know of that would allow that?
I'm not aware. What I recall of rainwater, because again, we did an amicus brief there, is that it was the case that challenged TWRA statutory authority to come on property without a search warrant. And the court said, under the U.S. Constitution, that's permissible. But the Tennessee constitutional provision on privacy sets a higher standard,
Protections, yeah.
and it was the state statute was unconstitutional thereunder. Now, if you look at rainwater, the court did not protect the statute from constitutional negation by saying, oh, here's a single example of where it could be done lawfully. They didn't do that at all. They struck that thing down completely. And so I don't think that the single incident argument has any validity, particularly under Bruin.
So in other words, this court is not bound by any precedent that we must apply the state's argument of this one, or the state's analysis of the test of one example gets us past the constitutional issue. You're not aware of any case that binds this court to apply that standard as opposed to the Bruin standard in this case?
No, Your Honor, I'm not aware of any case, and believe me, I've done too many appellate briefs and amicus briefs on Bruin. I'm not aware of any situation where it can lawfully be applied here. Take Beeler, for example. You know, I'm certain there are 18, 19, and 20-year-olds with felony convictions in Tennessee. Yet it wasn't raised. I'm not aware of an incident where a statute like this can be protected from constitutional scrutiny under the Bruin standard by demonstrating that it could be applied in another situation, particularly if that other situation involved additional elements.
Understood. All right, and then as far as the definition of intent, quote, to go armed, the state references in its brief that that's equivalent to the terror acts, the previous, that to go armed equals terrorizing the public, that has been upheld at various times. So is that accurate or not accurate?
No, Your Honor, we do not believe that's accurate. Every instance that we're aware of where you look at that language, particularly the ones that Bruin cites, those statutes are in the conjunctive. It's an additional element. And so there is not, to our knowledge, any of the what I call public assault cases where crimes of that nature would violate the intent to go armed, absent the inclusion of that additional element in the statute. And it's that additional element, the assault element, that gives rise to the terror. But the Supreme Court in Bruin rejected that argument.
Understood.
As a matter of fact, in Rahimi, it was not because of he was a dangerous person to the public. It was because there was an order of protection specifically against him, for example.
Understood. Judge Burke? Judge Rice? All right, well, let's take a morning break. It's 10:45, so let's take a morning break until 11 o'clock and reconvene then.
Thank you. Sorry it took so long.
Oh, no problem. We'll get through it.
Court is back in session. Come to order. You may proceed.
All right, gentlemen. Mr. Brandon, you ready to go, or Mr.? Oh,
Your Honor, I think I'm going to take the merits argument, and then Mr. Brandon is going to argue the procedural issues.
okay,
if
that'll
that's
be fine.
All right with the court? Good morning, Your Honors. My name is Alan Groves on behalf of the state defendants in this matter, along with co-counsel Mr. Brandon. And as I've just mentioned, I'm going to limit my argument to responding to Mr. Harris's merits argument on why the plaintiffs are not entitled to summary judgment as a matter of law and why the state defendants are entitled to summary judgment as a matter of law. The plaintiffs are asking this court to declare two foundational firearm statutes facially unconstitutional under Article 1, Section 26 of the Tennessee Constitution, which our Tennessee Supreme Court has said protects the same rights as the Second Amendment to the U.S. Constitution. And because they can't carry their heavy burden of showing that no set of circumstances exist under which those two statutes would be valid, the state defendants and not the plaintiffs are entitled to summary judgment as a matter of law. And I know Mr. Harris has spent a lot of time this morning giving us some extensive background on the broader statutory framework and some of the background legal principles, but I want to just jump right into what I think is the most important issue in this case, and that's what is the legal standard for this court to evaluate a facial constitutional challenge. Mr. Harris again conceded this morning that that is the type of constitutional challenge he's bringing. He is not bringing an as-applied challenge. That's nowhere in the complaint. He's never asserted that he's bringing an as-applied challenge. And the reason is because he wants to declare these two statutes facially void for all Tennesseans in all circumstances and all places across the state. But both the Tennessee Supreme Court and the U.S. Supreme Court have set a very, very high standard for a court to declare a statute facially unconstitutional, to essentially wipe it off the books. And that is, the plaintiffs have to establish that there are no set of circumstances under which the statute can be valid. That test was, I believe, first articulated in the Salerno case from the U.S. Supreme Court. It's been repeatedly adopted by federal and state courts. I think the most recent iteration in the Tennessee Supreme Court was from Fisher versus Hargett from 2020. So, Chancellor Mansfield, we do think that that is the standard that governs in this facial constitutional challenge. The plaintiffs cite no contrary authority, and Rahimi, which shortly followed the Bruin decision, reiterated that that is the standard for Second Amendment cases. There's no Second Amendment exception to this facial constitutional standard. Now, rational basis review, that's a form of means-end scrutiny. And so under some legal tests, you'll have rational basis, intermediate scrutiny, strict scrutiny. And we agree that's not the proper framework to be analyzing this under. We are happy for the court to embrace the Bruin methodological approach to analyzing Second Amendment claims, which is more of a text and history and tradition approach. But that's a separate question as to what is the standard when you're bringing a facial challenge. That's kind of a separate issue. So Tennessee does follow the Salerno rule. Rahimi reiterates that this is the rule that applies in Second Amendment cases. And I think it's important to emphasize that the plaintiffs don't actually identify or articulate a different standard. So they don't like the standard that you have to show that the statute would be invalid in all its applications. But if that's not what the standard is, then what is it? They haven't said anything about what the standard should be in their pleadings or at argument today. So I would like to hear about that so we could have a chance to respond to it. But I think it's pretty clear under state and federal precedent that we're left with the Salerno rule. They do have to meet this very heavy burden of showing the statute's invalid in all its applications. And my friend on the other side has spent a lot of time talking about how they are not necessarily challenging some other criminal statutes, which they say that's kind of their rebuttal to our argument, right? That, well, 1307, for instance, can be constitutionally applied in a school setting, but there's a separate statute that criminalizes possessing or carrying a firearm in a school, that somehow defeats our argument on the facial challenge standard. But that really doesn't prove anything. Because in the criminal law, as your honors know, there can be statutes that have overlapping spheres of criminal liability. A murderer can also be convicted of reckless homicide or a lesser included offense. In the State versus Welch case from the Tennessee Supreme Court in 2020, there was a constitutional vagueness challenge to the burglary statute. And one of the dissenting judges on the CCA had noted, maybe this defendant could have been or should have been charged with misdemeanor shoplifting or criminal trespass or something like that. And on appeal, the Supreme Court said, no, it doesn't really matter that there's other statutes that also might be relevant. What matters is this statute unconstitutionally vague? And they found that it wasn't. And so it doesn't matter, respectfully, that the 1307 statute only has two elements. The nature of a constitutional as-applied challenge is that there's always going to be other facts and other circumstances that you're going to be applying that statute to. It's not that you're adding an additional element that the state would have to prove. It's just the nature of an as-applied challenge. And as long as we can show some constitutional applications of both statutes, this court has to affirm them. And assuming that it, of course, has jurisdiction, which my friend's going to address in a few minutes. So I just wanted to lay the groundwork on what standard we're dealing with, and I'm happy to answer the court's questions on that issue if you have any before we kind of get more into the merits of the 1307 and 1311 analysis, because my intent is to kind of go through these two statutes and identify, as we did in our briefing, what we think are the constitutional applications of the statute. I'm not going to stand up here and say every single application of both statutes would 100% definitely be constitutional, because I don't need to do that in order for us to win. So that's kind of how I'm going to structure my argument, but I'm happy to address any questions the court has about whether the Salerno rule applies. I don't see anything in my friend's briefing on the other side that would suggest that it doesn't. He hasn't identified another standard.
Does the state have one example in which application of 1307A alone by itself would be constitutional?
1307A would be constitutional?
Yeah, in its application alone, without reference to another statute, without there being some
Okay.
other crime, such as a school, walking in a school, brandishing a weapon, assault and battery, something like that. Is there anything where there would be a situation where a person could constitutionally be charged under 1307 with no other statutory applications?
Yes.
All right, go ahead.
So in 1307A, it uses the word firearm, and that term is defined by 3911-106-13. And that's a very broad definition of the word firearm. And so you're not having to look at other statutes that criminalize carrying in schools or parks or anything like that. Just looking at 1307, that use of the word firearm.
1307A is our question.
Yes, 1307A uses the word firearm.
Right.
And that term is defined to include a broad range of weapons, including some dangerous and unusual weapons that are not constitutionally protected. It encompasses like explosive devices, grenades, bombs, things that maybe in ordinary parlance we might not call firearms, but that is the way the legislature has chosen to define that term in that statute. And so we have to go with the more specific statutory definition. And so if you're carrying a grenade with the intent to go armed, that's going to fail right out of the gate, even under the Bruin test. Because we both agree that if the plain text of the statute covers your conduct, then it's presumptively constitutional, and then we go into this historical analysis. But grenades are not arms within the meaning of either the Second Amendment or Article 1, Section 26. And Heller, all the Supreme Court's cases have made very clear that the Second Amendment does not apply to any weapon whatsoever, and that it's generally restricted to weapons that are in common use for self-defense. And so we would submit there's several examples of firearms, as that term's defined in the statute, that would not be constitutionally protected. So that would be the most obvious example, without even looking to other applications in other places, for instance, or with respect to certain individuals. But we do think that it's fair to look at those places, because there's nothing that would prevent the state of Tennessee from charging a criminal defendant who carried a firearm into a school, for instance, under 1307A. There's absolutely nothing that would prevent us from charging that person under 1307A. We could also charge them under this separate statute, but we could also charge them under 1307A. And that would clearly be constitutional as applied in that circumstance, because under Heller, under Bruin, every case that has come up before the Supreme Court, they've said, we are reaffirming the sensitive places doctrine. They haven't explored it in a lot of detail, granted, but they've said at least there's a few that have a historical tradition: schools, polling places, government buildings, courthouses, things like that. And there's just nothing in the text at 1307 that would preclude us from bringing a prosecution in those protected areas. So that would,
Let me see if I can boil that down to criminal judge. So you're saying that rather than charging the specific crime of place, they could charge, in essence, a lesser included offense, which would be a misdemeanor, a Class A misdemeanor of 1307A.
Correct.
And that's your example that it's applicable.
absolutely.
Okay.
And that's going to encompass a lot of different sensitive places.
Right.
It doesn't matter that this specific statute is not a sensitive places statute.
Right. I understand.
And another example, of course, would be applying this statute to a felon in possession. And I understand they're not challenging some of the later subsections of 1307, but again, there's nothing that would preclude the state from charging a lesser included. And that would be clearly constitutional. I don't even really take my friend on the other side to be disputing some of these applications. If the only argument is that we're not challenging those other statutes, that's not really much of a counter to our point. In fact, it's almost a concession, really, that like we recognize that those are probably constitutional. That's why we haven't challenged them. But that kind of just makes our point for us. We've referred the court to the United States versus Williams case from the Sixth Circuit decided last year that did say that there's a historical tradition, at least, of disarming dangerous people with violent felonies. And I know there's some discussion about whether you could disarm all violent or all convicted felons. Maybe if there was a prior felony like tax fraud or something, maybe that wouldn't be a historical tradition of that. I don't know. I haven't researched that. But certainly, at least the Sixth Circuit has said there's a strong historical tradition of disarming or restricting firearm usage by people who have committed dangerous violent felonies. And certainly, we could charge 1307A to those specific individuals without charging these additional crimes. And I do want to spend some time now on this going armed offensively application, because the statute does use the phrase, it is an offense to carry a firearm with the intent to go armed. And here, to establish our burden of showing the court a historical tradition, all we have to do is look at Bruin and Rahimi themselves, because those cases tell us that there's a historical tradition of restricting the use of firearms or carrying firearms that are intent-based. That's what Bruin says, is there's a strong history of intent-based firearms restrictions. Now, a lot of the examples they give do use that language of going armed to the terror of the people. And I think it's a fair reading of our statute to say that our intent requirement is kind of incorporating by reference that historical tradition. We know we have an 1801 Tennessee statute that also was a going armed statute, which is very similar to the one we have here. It's kind of a predecessor statute. But the way we're making that connection between intent to go armed to the terror of the people is the Kendall decision from the Tennessee Supreme Court, which interprets the language of intent to go armed to mean carrying offensively or defensively. And so we think offensively has that connotation of carrying with the intent to go armed to the terror of the people in some kind of intimidating and threatening way. And again, I don't really hear my friend on the other side disputing that history. He seems to be more taking issue with the fact that our statute doesn't use the exact phrase terror of the people. But that's really irrelevant, because the Tennessee Supreme Court has said that we're interpreting this intent requirement to include at least some type of offensive carrying, which is going to be at least analogous at a minimum to those terror of the people statutes that you find in some of the older cases. So we do think that even if carrying a handgun with the intent to go armed for self-defense, that is approaching pretty closely, if not directly, to what Bruin says is constitutionally protected. And we acknowledge that in our briefing. We're not necessarily defending that specific application of the statute. But certainly, on the other end of the spectrum, if you're not carrying for self-defense and you're carrying for some kind of improper purpose or going armed offensively, then that is something that the legislature has the power to regulate. There was a mention of the Simpson case from the Tennessee Supreme Court. This is a really old decision that the plaintiffs cite in their briefing. And I just wanted to emphasize that for that case, it's a little bit confusing. Some of the older cases are not as maybe as well written as this court might give us an opinion in, so they're a little bit hard to parse out. But that's a criminal case, and it's an appeal from a criminal prosecution where the person was charged with an affray, which the court said at the time had 3 different elements. Fighting between people that was in public to the terror of the people. And what the court said in that case is that the indictment in Simpson didn't allege facts on the first 2 elements about fighting between people. And it basically just alleged that this defendant had been carrying a firearm. And so the court dismissed the indictment and said that the indictment wasn't sufficient to allege a crime because just carrying a firearm by itself without any kind of additional context is constitutionally protected. But that's, I think, consistent with our position, that you would have to be carrying with the intent to go armed offensively in a way that's intimidating other people. So I don't think Simpson does quite as much work for the plaintiffs as they think. Similarly, the Andrews decision.
So why the other subsections? If subsection A encompasses everything that you need in the state, why go to the trouble of including every other subsection?
Well, as you mentioned earlier, Judge Burke, subsection A is just a misdemeanor. And so if you are charging somebody under, I forget if it's B or the ones that deal with convicted felons, for instance, those are going to be felonies. Right. So there's enhanced punishment for a lot of these other subsections, which I think makes sense when you're dealing with a different class of offenders.
Aren't you still subjecting yourself potentially to arrest, prosecution, posting bail, staying in jail if you can't post bail, even if it's a misdemeanor?
So I think that gets to the plaintiff's argument kind of about the broader statutory framework of whether the defendant has the burden of kind of proving up some of these exceptions and defenses on the back end. And I think that really goes more to a due process claim that hasn't been asserted here. So the due process clause of the Constitution does require the state to prove beyond a reasonable doubt every element of the offense. But the Supreme Court has said it is constitutional for the legislature to shift the burden to the defendant to prove certain exceptions or defenses. That's very common in the criminal law. We're very familiar with that. And there's constitutional limits to that. So the court, or the legislature rather, couldn't criminalize constitutionally protected conduct and then flip the burden to the defendant to prove an exception or defense, which is really what the plaintiffs are arguing. And we agree they couldn't do that. But they are assuming what they have to prove, which is that the statute does criminalize constitutionally protected conduct. But you can't just assume that first step. And our whole point is they have to show that the statute facially is criminalizing constitutionally protected conduct in all its applications. But if you fail that first step, then this kind of burden shifting argument that they're making really falls apart. You don't really get to that question unless you first establish that the statute is criminalizing something that's constitutionally protected. Which again, if they had brought an as-applied challenge, we might be in a very different posture here, and we might be making some different arguments. But even with respect to like arrest or reasonable suspicion to stop someone, our appellate courts have said that, this is from Atkins versus State, a 2008 CCA case, that officers are not free to ignore plainly exculpatory evidence that tends to exonerate the suspect. So it's just not true when Mr. Harris says that officers or district attorneys can't consider the availability of these very broad exceptions and defenses that a person might be entitled to. For instance, if there's a middle-aged person walking down the road with a handgun, it's a pretty safe assumption that they're going to fall within the permitless carry exception if they pretty clearly appear to be over 18 years old. And an officer is not free to just disregard that plainly exculpatory evidence. And they also have a duty to reasonably investigate an offense before they effectuate an arrest. That's also pretty well established in our criminal cases. And so this kind of parade of horribles that the plaintiffs portray with all these different ways that they could be stopped or detained, for one, it's just not accurate to say that officers and prosecutors can't consider all the exceptions and defenses. That's just legally inaccurate. But also, it really starts bleeding into more of an as-applied challenge, where you would be saying, like, under my circumstances, the way I want to carry this particular weapon in this particular circumstance, I'm afraid I might be stopped or detained or arrested or something like that. But here, like, we're so far, they lose the case so far before you even get to that point, because they have to show that both statutes would just be facially unconstitutional in every single application, and they just can't meet that burden. So I've gone through most of our arguments about the going armed statute under 1307 and identified all these different constitutional applications. The last thing I'll just say about that is that we did reference the Bodie decision, which applied intermediate scrutiny. I think the plaintiffs pretty dramatically overstate our reliance on that case. We cited that case because it's the only appellate decision we have in this state considering the constitutionality of 1307 under the Tennessee Constitution, and it seemed relevant to cite in our pleadings. And it was nowhere found in the plaintiff's pleadings. We thought the court should be aware that the only appellate court to consider the statute has found that it's constitutional. We're happy, though, for the court to apply the Bruin framework when analyzing the statute now. But if there's no further questions about 1307, and we can go back to it later if something comes to mind, I can now transition into the guns and park statute, which is 1311. So here, some of our same arguments that we raised for how the 1311 statute can be constitutionally applied, or 1307, are going to be incorporated by reference, because the guns and park statute also incorporates both the intent to go armed element and as interpreted by our office and apparently by the legislature through its subsequent statutory amendments, it also applies more broadly to all firearms. And so for the same reasons that we've argued 1307 can be constitutionally applied, for those reasons that it can be applied to those carrying with the intent to go armed offensively or to firearms that are not protected by the text of the Constitution because they're unusual and not used for self-defense purposes. Those same reasons would also apply to 1311. And if the court agrees with us on either of those points, you could just stop the analysis there and not even get into some of these other things about licensing and parks and whatnot, because those same arguments we've raised in 1307 would be equally applicable to 1311. But I do want to talk about the permit regime.
Hang on, Mr. Groves, before
Sure.
you get to that. It takes me a minute to get my brain caught up with what you're doing, okay? You
Sure.
guys are really good. So, all right, the Embody case,
Yes.
I believe, I don't know if I'm pronouncing that correctly. What level of scrutiny or what standard did it apply in its analysis to determine that 1307 was constitutional?
Intermediate scrutiny.
Okay. When did the test of any constitutional application come into play? Was that before Embody or after?
Are you referencing to succeed on a facial challenge, you have to
Yes.
say no set of circumstances exist?
Yes.
I think that dates back to the Salerno case, which was like 1970 something. So it very predated. the
Was
Embody.
Embody an as-applied or a facial challenge?
It was facial under the state constitution.
Then why did Embody apply intermediate scrutiny instead of just look at the one constitutional application standard?
So, yeah, I'm happy to address that. There are two different issues. So the first issue is, how do we decide whether the Constitution protects this specific conduct. And so that, there used to be intermediate scrutiny, and now we use the Bruin text, history, and tradition test. So that's one issue. But a separate issue is, even assuming we use Bruin to decide the scope of the constitutional right, how do you establish that you're entitled to facial relief as opposed to as-applied relief? And that's where the no set of circumstances test comes in. It really just speaks to a completely separate issue.
Okay.
Because we agree that intermediate scrutiny is probably not the best test to use now to define the scope of the right. And we're happy for the court to use the Bruin historical and textual analysis to decide that question. But even using that, that doesn't get them out of the Salerno test for establishing that no set of circumstances would exist under which the statutes can be valid. Does that address your
It does.
concern? Okay.
It does. Sorry to interrupt, like I
Oh,
say, it
no,
just
I'm-
takes me a minute to catch up sometimes.
Oh, no. I mean, I want to answer all the court's questions that you have because we want the court to rule in our favor. So if there's any questions, yeah, feel free to interrupt me. Going back to the guns and park statute, I kind of mentioned already how some of our arguments are incorporated by reference. But turning to the licensing issue. And here, I just want to do a little table setting first, because there's a lot of maybe rhetorical flourish in the briefing about how restrictive Tennessee is in our firearm regulations. But Tennessee is extremely permissive on carrying guns into public parks, especially when you consider the history, which our two experts that we've submitted to the court have discussed in detail. Those are uncontroverted expert reports. All of that evidence is before the court for your consideration, and I'm not going to go through that and read all of that to you. But what you'll find is that from the inception of the creation of public parks, firearms were almost universally prohibited, completely prohibited. Tennessee liberally allows citizens to carry handguns into public parks. You just have to have a permit. And in Tennessee, in particular, we have a shall issue permitting regime, which Bruin speaks very highly of. In Justice Thomas's opinion, also in, I think, Justice Kavanaugh's concurring opinion, they say nothing in Bruin should call into question the 43 other states who have shall issue licensing regimes. New York had a very strict may issue regime where there was complete discretion for state officials to deny you a permit. You had to show special need or proper cause that you needed the permit to carry for self-defense. That's nothing like Tennessee's regime. We have a shall issue regime, so as long as you meet some basic criteria that are objective and narrow, which plaintiffs I don't even think dispute, you're going to get the permit issued to you, and then you can carry your firearm into a public park.
When was that regime enacted?
I don't recall the exact date, Your Honor. I want to say it was close in time to the 1989 Sentencing Act.
That was the number I was thinking. So what happened between 1870 and 1989? What
Sure.
kind of regime did Tennessee have then?
So I don't think that we do have some historical examples in the briefs where you had some local, municipalities requiring licenses from, I think
Oh, I
it was
get that,
a
but I'm talking
Memphis-
about, you're talking about the Tennessee's a gun-friendly state and
Sure.
allows all this kind of thing, and so the permitting may or may not, I don't know, but that may, it sounds like you're basing your argument on the permitting scheme in Tennessee allows all this carry, and we're very open.
in parks.
In parks, okay. But what happened before 1989?
Well,
As far as the application of 1307A or the park statute or whatever, what happened as far as citizens' ability to open carry a firearm for self-defense in the state of Tennessee between 1870 and 1989?
So going back all the way to 1801, we had a going armed statute, which made it a crime to carry with the intent to go armed. So all the way back to 1801. That's the closest historical analog I think you could get to for 1307 purposes. Now, the parks they weren't really created even until around the time of the 14th Amendment, which I know that has also been brought up today. And I do want to address that briefly because I think this kind of is responsive to your question as well. Bruin and Rahimi both leave open the relevant time period. as to whether you were looking only at the founding or the 14th Amendment. Rahimi came after Bruin, and it specifically said, even in that case, like, we're reserving that issue for another day. And certainly under that analysis, we have a strong, uncontroverted historical record in this case that firearms were almost universally banned in parks around the time of the 14th Amendment, which is around the time that the parks movement began and started creating these state and federal parks. So to the extent that the 14th Amendment timeframe controls were certainly in solid territory there. But even if we go back to the founding, we've still got analogies that we can point to the surety laws, Chancellor Mansfield, and other concealed carry restrictions, some of the local licensing requirements we pointed to for discharging or disposing of weapons in certain municipalities. So we also have those other analogs that we can point to. And Bruin and Rahimi also have a pretty extensive discussion of the surety laws, which are not exactly the same as licenses. But Rahimi tells us that when we're looking for historical analogs, we're not looking for a historical twin. It doesn't have to match on all fours. You're kind of looking to the general principle that's animating these laws. And so we would urge the court to kind of take that type of approach that was ratified in Rahimi rather than a more specific and narrower approach that the plaintiffs are advocating for. And again, the plaintiffs are not challenging. They've never challenged the constitutionality of our licensing regime. And again, I think that in their mind, that is an advantage to them, but it's really not, because even though they're not challenging those separate statutes, all we have to do to win this case is to show how this statute can be constitutionally applied in certain circumstances. And so if the permitting regime itself is constitutional, then that means you would be able to apply 1311 to non-permit holders. So it doesn't matter that they're not challenging the permitting regime separately from this 1311 claim. And of course, obviously 1311 implicates the sensitive places doctrine. This is the other example we've used. It is a sensitive places statute, just like we have other sensitive place statutes with schools and government buildings. And so here, we've laid out a lot of history for the court, again, that I'm not gonna repeat and read to you, but again, universally, since the creation of the public parks, firearms were universally banned or restricted. And we have a couple of cases from the Second Circuit Court of Appeals and the Ninth Circuit Court of Appeals that both rejected facial constitutional challenges to similar parks restrictions just last year in 2024. And that's the most recent authority that I'm aware of on this issue, surveying very similar historical records and rejecting facial challenges. The Antoinette case from the Second Circuit, the plaintiffs had tried to make an argument, which kind of sounded like something that I heard this morning, that perhaps maybe there's not a historical tradition of regulating parks in sort of rural areas, rural parks and things like that, but maybe there is a better historical tradition of regulating firearms in more urban parks and areas where there's a lot more people. And in the Antoinette case, they said, yep, we definitely see a tradition of regulating guns in urban parks. There's a lot of evidence of that. And because you brought a facial challenge, we're rejecting your claim, regardless of what the historical evidence would show as applied in other situations. And that's the type of analysis that we're asking the court to adopt here as well. But even separately, putting the parks aside, this 1311 statute, it doesn't just apply to public parks. It also applies to government recreational facilities, playgrounds, other areas that are specifically enumerated in the statute. Certainly playgrounds would be easily analogous to the school setting when you have children present and a vulnerable population. So that's going to be analogous to another well-recognized sensitive place that the Supreme Court has said is a sensitive place. Polling locations where you have voting going on, we've provided the court with proof that many, both public parks and government recreational facilities, I vote in my community at a county rec center. So when those facilities are being used for voting, that's per se going to be a sensitive place under the court's current sensitive places doctrine.
All the time or just on election day?
Well, see, it doesn't matter because they're bringing a facial challenge. So even if it is just on election day, that's a constitutional application of the statute. And again, I kind of understand the reticence here when we're saying, well, just this one thing. But if your honors will consider all the different ways we have shown in our briefing that these can be constitutionally applied, we're not just hanging our hat on one day, on one election day, right? We have so many different constitutional applications that we can point to here. We've also shown that rec centers are another place that you can analogize to schools because there's so often children's activities and sports gatherings, after-school programs that are often held at these places. So yet again, here's another example. And the court just needs to agree with us on maybe one of these that we're giving, even though we've established several constitutional applications for both statutes. And I know I'm going fast and there's a lot of material here, so I'm happy to slow down for a second if there's other questions. But kind of the way I wanted to conclude my part was to, again, circle back to the burden shifting, because I do feel like that's kind of a major theme in the plaintiff's argument, that they're very uncomfortable with the fact that you have a broad criminal prohibition that puts the burden of proof on the defendant to establish an exception, or if you're talking about a defense, maybe to introduce evidence at trial that would fairly raise the issue, and then the state would still have the burden of disproving the defense beyond a reasonable doubt. So I did want to address that here at the end. I know I kind of previewed it in response to one of your Honor's questions, but the reason that whole line of argument is a red herring is because it presumes that the statute criminalizes constitutionally protected conduct. But you can't just assume that it does and then wave your hands and complain about the burden shifting. You have to first establish that it does facially violate Article 1, Section 26. So that's the main issue before this court, is whether 1307A and 1311 facially violate the constitutional protection for the right to carry firearms. If it doesn't, because there are constitutional applications of the statute, you don't get into the burden shifting argument, which is really, again, more of a due process claim. And there's cases talking about this. I don't think this one is cited in my brief, but there's a D.C. Circuit Court of Appeals case called Harrington versus United States. And this is interesting because it's from the District of Columbia, which is also where Heller originated from. So Heller, as a reminder, held that the Second Amendment does protect an individual's right to carry or to possess a firearm in your home for self-defense. Harrington involved a criminal prosecution of a defendant who possessed handgun ammunition in his home. He was prosecuted for that. And he challenged this on appeal in an as-applied constitutional challenge. And the D.C. Court of Appeals actually agreed with him that that was unconstitutional as applied to him. And it said, under Heller, there's this new constitutional right to possess a firearm in your home for self-defense. We think it naturally follows that you should be able to possess the ammunition for that same handgun in your home for self-defense, which we agree with. But it said that in D.C., the defendant had the burden of proving that he had a license, or I think it called it a certificate of registration, for a handgun that matched that ammunition. So it was structured as a defense, or I think it might have called it an affirmative defense, but it put the burden of proof on the defendant to prove that he had a license for the handgun that the ammunition went to. And the D.C. Circuit said the due process clause is what that offends, because due process is what requires the state to prove every element of the crime beyond a reasonable doubt. And you can't criminalize constitutionally protected conduct, such as the possession of ammunition of a handgun, and then flip the burden of proof to the defendant to show that they had a license. And again, that is similar to what the plaintiffs are saying. And I kind of debated whether to bring this up to the court, because I think this kind of makes the case better than they did. But the reason I'm doing so is because it really helps us, because that was a criminal prosecution an as-applied challenge. And the court expressly said, we're not reaching the facial challenge here. We're not going to address, for instance, could you apply that constitutionally to possessing ammo for like a long gun, something that's not a handgun, or an arm that's not constitutionally protected. We're not going to address that. That's a facial thing. We're not going to address all these other applications because it indicated it very well could be constitutional as applied in certain situations. But because that criminal defendant had raised an as-applied due process challenge to that burden-shifting framework, that's how he was able to succeed on that claim. That is nothing like what this case is about. This is a pre-enforcement declaratory judgment action seeking facial constitutional relief, asking this court to just wipe both of these statutes off the books, no matter how they could be applied constitutionally in any variety of circumstances. And we think that the plaintiffs have not shown that they're entitled to judgment as a matter of law, so this court should deny their motion for summary judgment for this reason alone, notwithstanding all of the procedural issues that will be discussed later today. And instead, we think this court should grant summary judgment in favor of the defendants because there's no issues of material fact on this issue, and we've shown pretty clearly that we are entitled to judgment as a matter of law. I'm happy to address any other questions the court has on the merits.
Judge Burke?
I guess my question would be, would your analysis change at all if this case were, or your conclusion rather, if this case were brought as an as-applied case?
It certainly could change our approach. It would depend on what type of as-applied challenge and what the facts
Well,
were.
I guess what I'm getting at is under 1311 and as-applied, what I'm understanding from your argument is an as-applied challenge under 1311 could look different in Sevier County than it could in Moore County or various counties if they have various state parks. The makeup of those, or Davidson County, for instance, or Shelby County. So I guess my point is would your argument on 1311 be different if this were an as-applied case?
Yes, it very well could be different. I would just have to know more facts about what the specific as-applied challenge was. Was it at a park? Was it at a playground? Were they wanting to carry a handgun? Were they wanting to carry a long gun, like a rifle? All of those things are relevant and could change the analysis. And so that would be the more appropriate way to challenge both of these statutes, but especially 1311.
Okay, thank you.
Judge Rice?
And so I believe kind of the agreement was that Mr. Harris would have an opportunity to respond to what I've said, and then that I would come back up and have any kind of sort of rebuttal is kind of my understanding.
That's fine. All right. Thank you, Mr. Groves. Mr. Harris?
Generally, I believe that most of the argument of the respondent is addressed in the briefs, but I do want to make a couple of specific points. Look at, for example, 1307A and the state's argument that on a facial challenge, if there's any constitutional application, then the entire challenge fails. And they point out quite quickly that even though 1307A uses the term firearm or club, it's not the common layman's definition that's really applicable. It's this sort of weird definition that you get looking at 1311-106 that defines a firearm to include a whole host of non-firearm types of implements. Grenades, for example, was one he mentioned. And I think the problem with that argument and the statutory structure that's being advanced is by changing the definition of a common term to include things that ordinary civilians can't own or possess. such as a grenade, typically, that the state is seeking to do what Bruin said can't be done. Keep in mind, Bruin said you can't define an entire area like Manhattan as a sensitive place and thereby attempt to invoke an exception to the constitutional protection. What we're really seeing when you peel back the layers in the state's argument is they want to say, because we're defining a firearm to include things that aren't firearms, and we're defining a firearm to include things that are arguably outside the scope of the Second Amendment, that 1307A survives constitutional challenge if someone possesses one of those unprotected items and can be prosecuted because we include it in the definition. I think Bruin makes clear that you can't play that kind of game with a constitutional right, because the consequence is if you do and you get away with it, you entirely circumvent the Second Amendment as a protected right. If, for example, all they'd have to do is say, from this date forward, firearms includes, just pick something, battleships, or it includes nuclear submarines. And just because theoretically somebody could own or possess even one and be prosecuted, therefore all the things that are clearly covered within the scope of the Second Amendment can be constitutionally denied the protections of the Second Amendment because we chose to create a definition that took us outside of it. And that's exactly what the Bruin Court said you can't do.
How did the Bruin Court say that? How did they define the, quote, game, as you put it? And then what did they say about how they banned the game of redefining this term? Is that just the overarching theme of the case? Or
No, that's specifically the court's references to, hey, state of New York, you can't define the island of Manhattan as a sensitive place and then attempt to.
But that's under the sensitive place doctrine, right?
It is.
Like, we're not talking about, those are two different concepts.
To some extent, yes, I agree with Your Honor. But the point I'm making is they're trying to define a sensitive place in one instance, a item in another, in both instances to circumvent the constitutional protections. And that's why I think the court's statement about you can't create a sensitive place just by defining it is relevant, because the constitutional protections are of critical importance. And the game that the state plays or has played or is asking you to even ratify is that because we can, in our discretion, define things that aren't historically considered to be firearms as firearms, we can defeat the application of the Second Amendment anywhere in the state. Isn't that essentially the argument? If we define firearms to include battleships or laser-capable satellites and make those things illegal for citizens to own, then you could never bring a challenge in the state of Tennessee, facially or as applied under the Second Amendment. Because they could always point to this, well, we could prosecute somebody carrying a battleship with the intent to go armed or possessing a battle. I mean, it's a game that Bruin says, but by that analogy of you can't define a sensitive place, you can't circumvent, you can't create these loopholes to defeat the protections of the Constitution by gaming the system. And that's exactly what we're seeing. I mean, if you look at the firearm example, and they're saying, well, we defined a bunch of things like grenades or rocket launchers or whatever that civilians can't own lawfully, we're thereby going to defeat all of your rights for things that you can own lawfully. And in fact, not just own, but are the only items of personal property protected in the U.S. Constitution to individual ownership. And that's not something that Bruin would sanction because of the example it gave on allowing a state to redefine what's within the scope and what isn't.
So are the plaintiffs bringing only a facial challenge, or are the plaintiffs bringing both facial and as-applied challenges in this case?
In this case, this is just a facial challenge.
Only facial. So is the state right about the standard this court is bound to apply with the one constitutional application? Is that a correct statement of what this court, the standard this court has to apply to this case?
I think to some extent they're correct, because Rahimi clearly says that Serrano case about can it be constitutionally applied anywhere, Rahimi does say that. But I think you got to read Rahimi and Bruin together, and you got to look at the circumstance. And so, for example, when we talked earlier this morning and some of the questions the court had about 1307 and the facial challenges that they brought with, for example, a felon or someone possessing the illegal weapons, all of those implicated additional elements. Right. And that's what takes it outside of the we can enforce it because this person could have been charged. You know, I think you may have used the phrase lesser included offense. Well, the fact that when you look at the elements of this offense, okay, it's that they possessed a protected item and were engaged in a protected activity, carrying with the intent to go armed. All of the examples that you've been given as circumstances that defeat the facial challenge analysis are circumstances that implicate additional factors. None of them stand on their own. I haven't heard the state tender, and I didn't read it in its brief, that there's any instance anywhere in the state where carry with intent could be prosecuted based solely on those elements, with the exception of what they just said on their response of, well, we've redefined what's a firearm to include things that aren't firearms, and therefore we think we have defeated the Second Amendment's application anywhere in the state. Because even if I'm going to prosecute you for carrying that handgun and you weren't carrying the bazooka or the tank or the battleship, because those things are firearms, there's no facial challenge. I think Bruin says quite clearly, if you can't redefine a sensitive place to include things that aren't sensitive places, then as a constitutional matter, you can't redefine firearms to include things that aren't constitutionally protected firearms. And that's part of the problem with where we see the defense arguments going. There was a brief discussion by my friend about the exceptions and defenses. It, I think, was a commentary on my statements earlier about when you look at the statutory scheme, everything that would, in our existing statutory scheme on these two statutes, that would allow a citizen to escape a conviction. Keep in mind, they don't escape, stop, detain, question, possible charge, arrest, or the need to hire a defense attorney if they don't get a public defender. All of that they still got to do. All of those defenses, the only time our statute or our case law requires that they be elaborated on or evaluated, and that's the key, that it's required, is when you're at trial. While the police officer, and I agree, the police officer has discretion. They can look at it and go, you know, why am I wasting my time? If I arrest you and you've got a permit, and let's assume your permit's valid, it hadn't been revoked, then I'm wasting my time and I'm going to waste your time, so I'm not going to charge you. That's a discretionary, subjective call. But the point is, under the statutory scheme, they're not required. There's no affirmative duty for them to engage at that point, that analysis. They can charge you and let the chips fall where they may. And so, while officers can do it, the statutory scheme puts the citizen at risk for all these other activities and all these other burdens merely for exercising what we contend is a constitutionally protected right. I think there was a question about the parks statute. I'll share that I've been practicing since 1986, which was just prior to the adoption of the 89 code, where I think it was a 200-something page bill that recodified the criminal code. My recollection is that the parks statute came into existence in Tennessee in 89 with the recodification. It was a very short statute back then. That's a recollection. I'm not going to vouch for the accuracy. What I do know is it was Senator Beavers in approximately 2008 that carried the legislation in the General Assembly that created the exception for permit holders. And that was driven by the Attorney General's interpretations of the act as much as it was the language of the act itself. Because if you look at those AG requests, the legislators are specifically asking, is the parks statute limited by 1302A? And the AG was the one saying, no, it's not. The other thing that I'll share is when you looked at the carry with intent statute that existed when I started practicing in 86, it was very similar to the 1801 Act that's been talked about. It was Bowie knives, it was all kinds of brass knuckles, all kinds of other weapons. It was a very short statute. But what was interesting about it, and this is because of Andrews, is it expressly exempted the military-grade handgun from coverage. And that's because, going back to Andrews, the court says those are constitutionally protected. You can prohibit these other weapons, but constitutionally you can't prohibit weapons protected by the scope of the Tennessee Constitution or the Second Amendment, which at that time they thought was limited to military-grade weapons. Look at Andrews. That's the basis on which the act that existed when I started practicing in 86 expressly exempt. Literally, you could walk through downtown Nashville with a military-grade weapon because the statute said you could carry it, but it had to be openly in your hand. Who did that? But it was constitutional because Andrews said it was constitutional. I mean, that's the way the statute was written. On the discussion from my friend with the AG's office about 1311, they proffer a number of what I consider to be sensitive places to try to defend the park statute. But a theme that runs through that is sensitive places presumptively include anything where there are children. Now, clearly, that's the way the school ground statute 1309 is written. Again, it has express exceptions for teachers, faculty, staff, and permit holders to some extent. But again, we have this issue, the problem with Bruin and Manhattan, the warning that the court gave that you can't take places where the population congregates, where people assemble, particularly in areas where there's no government security or government threat, like maybe a legislative body, and define them as gun-free zones and define them as sensitive places. So I think even with these proffer, and it's demonstrated by their, I think, plea for the security of the children, you can't create sensitive places in that. In fact, when you're talking about parks, it may be that the only people around that can provide any security at all for the children are parents who could be armed. I mean, I certainly feel that way in the Smoky Mountains. If I'm out on trails, I much prefer to have something other than a stick if confronted by any type of wild game. I don't have additional comments that I wrote down that I wanted to talk about. If there's any questions, if not, I'll return to my seat.
Judge Burke?
Nothing.
Judge Rice?
Thank you.
All right, Mr. Harris, thank you.
Thank you.
Mr. Groves?
Yes, Your Honor, I'll be real brief. Just a few quick points on the facial standard. I think I heard Mr. Harris basically concede that the no set of circumstances rule does apply. I think he said something like you have to look at Bruin and Rahimi together. but I'm not sure what that means. He hasn't articulated a different standard for this court to apply. If you pull up Bruin on Westlaw and Control F for facial, you won't have any results. It doesn't purport to be a facial constitutional ruling. It doesn't say it's changing the standard for bringing facial constitutional challenges in Second Amendment cases. It just doesn't address it. And Rahimi, immediately after that was decided, clarified this is the standard for gun cases. With respect to the going armed statute, there's some further discussion about the definition of firearm, and it's pretty well settled under our normal canons of statutory interpretation that we normally do apply the plain and ordinary meaning of a word unless there is a more specific statutory definition of the term, which is what we have here. So it might feel unnatural to use firearm in that broader sense, but that is the way the legislature's chosen to define that term in 1307, and that's what the court needs to go by. With respect to the burden shifting, again, I don't think my friend on the other side is right, that officers simply just have discretion about whether they consider exculpatory evidence or the existence of exceptions of defenses. My understanding of Tennessee criminal law is that there is a duty to reasonably investigate and to not ignore plainly exculpatory evidence, which I think we've cited previously in our discussion today.
Let me ask you something about that.
Yes.
So let's say that someone's walking down the sidewalk with a sidearm with a handgun on their hip, and an officer walks up and asks, hey, what are you doing? They say, well, I'm going to the store. Why do you have that gun? In case somebody attacks me. And then the officer just doesn't believe them. Is
Yeah.
there a civil rights violation in that? When you say there's a duty to consider exculpatory evidence, I mean, what's the enforcement mechanism of that duty to either ferret out or to believe exculpatory evidence?
So what I'm hearing in that hypothetical is that the person is carrying with the intent to go armed for self-defense. Which-
That's what the person stated. The
Yes.
officer observed the weapon on the hip of the person walking down the street. The person says plainly, I'm carrying this weapon in case someone attacks me so I can defend myself. Now, what's the penalty if the officer ignores that? Is there any penalty to the officer if he ignores that and just proceeds to arrest the person for going armed?
So as in any other circumstances, officers have to consider the totality of the circumstances and make a reasonable decision based on that evaluation of the totality of the circumstances. And they have to have probable cause to effectuate an arrest. And probable cause, as the court knows, has to be based on specific articulable facts. And so if the officer doesn't have those specific articulable facts to justify a detention or an arrest, then any kind of criminal process is going to fail in the end.
Well, would not the probable cause be that he saw someone carrying a firearm that appeared to be with the intent to go armed, and then despite the person's protestations to the contrary, the officer still has probable cause that there's a violation, a facial violation of the statute, and took the person in? Is there any penalty to the officer when you emphasize that the officers have a duty to not ignore exculpatory evidence, okay? That implies that there is some penalty to the officer or some enforcement mechanism for that duty. Is there one other than taking the person through trial and having an unsuccessful verdict at the end once that person establishes the defense of these exceptions?
Sure. So I'll confess, my general practice is criminal appeal, so I'm not involved as much in civil rights litigation, like 1983 claims. I would imagine that there could potentially be some arguments about qualified immunity or something in that situation, but I wouldn't be able to answer the details about the officer's specific civil liability. Maybe my colleague would be able to address that better.
So there's no statutory anything to it, and there's no statutory or regulatory enforcement of this duty that you indicated. You said they have a duty to not ignore exculpatory evidence, but if the officer just says, I didn't believe his statement that he looked like he was going to rob a bank to me, and so I disregarded his statement, is there any law or legal enforcement mechanism of the duty, as you put it, on the officer?
As I said, I'm not aware specifically one way or the other, and that kind of gets into another area of law that's just not really directly implicated in this case.
And
So
I
I haven't
understand.
researched that, but I could look into it if the court wants.
But you heard Mr. Harris talking about that there's levels of exercise of discretion. So there's I guess a balancing going on or a tension. does the government have the authority to, in the first instance, be able to disarm a citizen or to accuse a citizen of a crime for carrying a weapon? Or does the officer first have to have probable cause that the citizen is using the weapon in a criminal manner? You see what I'm saying? That's kind of the tension. That's what Mr. Harris was talking about, is that, yes, you've talked about discretion and you can't ignore, and then you indicate that the officer and the prosecutors, they have a duty not to ignore exculpatory evidence, but, people get acquitted all the time after jury trials.
Sure, and under the Fourth Amendment, there's like officer safety exceptions that would allow temporary seizures of firearms, and there's a whole nother body of law for things like that. So, but those are just issues that can be addressed on a case-by-case, as-applied basis. Okay. So the last thing I was just going to mention is I know I did reference that Harrington decision from the D.C. Circuit Court of Appeals. I do have copies of that opinion. If the court would like copies, I brought one for opposing counsel if your honors are interested.
That'd be great.
Okay. But other than that,
as long as you give a copy to opposing counsel, we're good. Madam Clerk. The officer's coming to get it.
And just to sum up with this case, I do think this is a good illustration of how you would properly bring an as-applied due process challenge to the burden-shifting concerns that the plaintiffs have addressed. And it's another example of a court declining to grant broad facial relief to a statute when you're only confronted with a specific unconstitutional application.
I have one quick question before you depart. In your appellate work, and this is more practical application, but in your appellate work, do you often and regularly see testimony of the arresting officer state something to the effect of, after I establish probable cause, I place the defendant under arrest, and at that point the inquiry stops?
Yes.
So that regularly happens?
Yes.
Anything else based on my question?
Judge Burke?
I guess I'm just interested in, this is just an overall question, not specific, but I think one of the more compelling analogies, if you will, that I read in preparation for today was the analogy of the First Amendment. And would you agree that each one of these rights are equally weighed? First Amendment to Second Amendment. Are you in agreement that those are both important, protected, et cetera?
I obviously think all the rights that are protected in the Bill of Rights are
I know that's a silly
important.
question, but it leads me to this point. Everything that we've discussed here today, it seems to indicate to me that citizens would have to explain themselves for their conduct for carrying a weapon under 1307A and under 1311 to law enforcement. And I say all that to say, in an example I believe given by the plaintiffs, they indicate that the requirement to explain yourself for speech is not something that we historically accept, right? You don't analyze every single word that you're going to say before you say it for fear of prosecution. But it seems like to me under 1307 and 1311, if you carry, you're subjecting yourself to having to explain yourself about why you're doing that. Would you agree with that statement overall?
Maybe in certain applications. And
Okay.
again, that's just, what's frustrating about this case is the way the plaintiffs have brought it, because they are seeking facial relief, not as applied relief. So if you're carrying with the intent to go armed, to intimidate other people offensively, or if you're carrying a
How are you
firearm.
ever going to gain that information without first being
So the
detained?
intent might be a little bit harder to see with your eyes.
Right.
But if you're carrying a dangerous, unusual weapon, if you're carrying a grenade, as we mentioned, that falls within the statutory definition of firearm, you can see that. And
Right.
you're not going to have to explain it. Like, the officer's going to know you're not carrying a handgun for self-defense in that situation. The other thing I'll say about First Amendment cases, and I take the point about this concern about constitutional rights receiving equal treatment, but under our current appellate court precedent, there's a different standard for facial challenges for First Amendment cases. And they talk about the plainly legitimate sweep test, and the law has to substantially, the unconstitutional applications have to substantially outweigh the constitutional applications. And I think the Moody versus Net Choice case from the U.S. Supreme Court last year is the most recent discussion of that. It was a social media moderation case. But under the current precedent, there is this slightly different standard for facial challenges in a First Amendment context. But as a lower court, we've got to apply the law as it exists right now.
I understand. Thank you.
Judge Rice? All right, thank you, Mr. Grove.
Thank you, Your Honors.
All right. Yes, sir, Mr. Harris.
Just two, I know there's,
Only with permission of the opposing side. So, Mr. Groves, I guess you're still in charge at this point. Mr. Harris is asking for an opportunity to bring up 2 points, but you have the option as to grant him that permission or not.
I mean, if it's limited to something I've just said, I have no objection, but we would like to move the case along.
Understood. Mr. Harris, can you limit it to what he just said, and can you do it in under 2 minutes?
yes, Your Honor.
All right, then go ahead.
It's really a comment as to the First Amendment question that was asked that I'd like to comment on. And it does implicate that exact parallel, and I think that the court's jurisprudence on the Second Amendment picks up the First Amendment parallel. It's part of the reason why they adopted in McDonald or used the incorporation doctrine. But for example, if you apply that on First Amendment grounds, we all heard the example that you can't yell fire in a theater, okay? And so, if there
Well,
was
you
a First
can, but there's consequences. Yeah.
Exactly. But under the facial challenge analysis that is being urged, you would never bring a facial challenge on a First Amendment ground if the state then turned around and argued, well, but if you'd said fire, we could have prosecuted you, because it would be a permissible prosecution under First Amendment jurisprudence. And that's one reason I think that the examples that we talked about earlier about all of the enforcements that they say are constitutional implicate additional elements like asserting fire in the First Amendment. The other thing I think that came up on the last statement, if I'm not incorrect, is although typically the firearms definition is broader, when you do look at 1302A, there are defenses to possession of things like the machine gun or the hoax device or explosives. Those defenses are in 1302A, so merely the possession of the item doesn't give rise to a conclusive determination, probable cause, that it's a criminal offense. There are defenses that apply. With that, I'll try to stay under 2 minutes. Thank you.
All right. Thank you, Mr. Harris. All right, so we're about to move into a separate section. Mr. Brandon, I know that you're ready to go, but hang on. So we've been going for a little while. It is the lunch hour. We'll give you guys a minute to freshen up. So we'll come back at 12:30. Court's in recess. right, Mr. Brandon, you ready to go?
Yes, Your Honor. Good afternoon now, Your Honors. Cody Brandon here from the Attorney General's Office on behalf of the state defendants. We've heard extensive argument, which I've quite enjoyed, getting to take an audience seat to on the merits here, and I think General Groves has demonstrated why the state defendants are entitled to summary judgment on the merits, because the plaintiffs have brought the wrong challenge here. There's three more issues to which the state defendants are entitled to summary judgment. First, the plaintiffs have brought their claim in the wrong court. Second, they've brought their claims against some of the wrong defendants. And third, they've sought the wrong relief. So to start with that first one, being in the wrong court here. This court addressed a similar issue in the briefing on the motion for temporary injunction that this court ruled on quite some time ago, and concluded correctly that this court did not have jurisdiction to enjoin a criminal statute. We're asking here that this court just apply the logical conclusion of that holding and also hold that it doesn't have jurisdiction to declare the constitutionality of a criminal statute. The Declaratory Judgment Act does not expand any court's jurisdiction, and we've got Supreme Court precedent stretching back decades, probably over a century at this point, that repeatedly affirms that the Declaratory Judgment Act is a vehicle for relief on an underlying claim. And so when a court has jurisdiction to adjudicate the underlying claim, it can offer a declaratory judgment as an alternative or additional remedy. But nothing about the Declaratory Judgment Act expands anything about the underlying jurisdiction of the court. And here, it's very clear, chancery courts do not have jurisdiction over criminal matters. They don't enforce them, they don't interpret criminal statutes, they don't enjoin criminal statutes, and as a consequence, they shouldn't be declaring anything about the application or constitutionality of criminal statutes. That principle is in accord with multiple published binding decisions from the appellate courts in this state. I'd refer your honors to, these cases are cited in our brief, the Spoon versus the Mayor and Alderman of Morristown case, published from the Tennessee Supreme Court, the Memphis bonding case, published from the Tennessee Court of Appeals, and then the Carter and Frazier cases more recently from the Court of Appeals that are unpublished, but we think just naturally, again, extend that rationale that's been repeated since the time of Zirkle and Hill, that a chancery court can't undertake to declare in an action what it could not have adjudicated in the first place. And here, the courts that are responsible for adjudicating the application of criminal statutes to all of the hypothetical circumstances that your honors have discussed extensively today are criminal courts. This chancery court doesn't have that jurisdiction, so it doesn't have jurisdiction to enter a declaration. There's two decisions, primarily two buckets, I guess, of decisions that the plaintiffs have relied on, ask this court to deviate from that longstanding rule. The first is the Clinton Books case, the only published authority that the plaintiffs rely on. That comes from the Tennessee Supreme Court. And I'd ask your honors just to give that case a very close read, because it does not stand for the proposition that plaintiffs assert that chancery courts can have jurisdiction to enter declaratory judgments about the application or constitutionality of criminal statutes. What was at issue in Clinton Books is that a chancery court had received a complaint asking for both injunctive and declaratory relief. It held a temporary injunction hearing, and without giving any notice to the parties, accelerated under Rule 65 the temporary injunction hearing with a hearing on the merits, and granted a declaratory judgment in favor of the defendants there on the merits along with the temporary injunction hearing without any notice to the parties. So the Tennessee Supreme Court there reaffirmed what it had said many times before, that the Chancery Court lacked jurisdiction to entertain any proceedings for injunctive relief. And then it said the trial court, a Chancery Court, improperly consolidated the hearings without giving the parties any opportunity to make any arguments about the propriety of a declaratory judgment. And for that reason, it remanded on that procedural ground to the trial court for further proceedings on the merits of the declaratory judgment claim. What it didn't say was that either party had contested the jurisdiction of the Chancery Court to entertain a declaratory judgment action, and I think the procedural posture there expressly left open that possibility because the parties had never had an opportunity to make any arguments about the propriety of declaratory judgment action because the trial court improperly consolidated the proceedings there and expedited them. That's the issue that Clinton Books addresses. It does nothing to upset the longstanding precedent of Zirkle and Hill and the other cases that we've cited that the Declaratory Judgment Act cannot expand the underlying jurisdiction of the Chancery Court.
So the issue in Clinton Books, was it subject matter jurisdiction? That's what you're saying, that the court in that case, the underlying trial court, did not have subject matter jurisdiction?
Yes, Your Honor. And the Supreme Court addressed that with respect to the injunction issue and then sent the case back to be revisited in light of its holding that it improperly consolidated a hearing on the merits with a temporary injunction hearing.
Why would the Supreme Court not have just adjudicated the complete subject matter jurisdiction issue, since it can be brought up anytime by any party, by any court, sua sponte, however subject matter jurisdiction stops the whole train? Why would the Supreme Court go through all the trouble of going through a subject matter jurisdiction analysis on the injunctive part, but then send it back to a court that didn't have subject matter jurisdiction when the Supreme Court could say, hey, you know, by the way, this court doesn't have subject matter jurisdiction of anything, so we're just going to dismiss it? Why would the Supreme Court multiply litigation like that?
Your Honor's right that subject matter jurisdiction can be raised sua sponte by a court, and court, just as this court does, has a duty to examine its jurisdiction. This court should do that here at the summary judgment stage. As to why the Supreme Court didn't venture into that question, there are a lot of things. I won't purport to know, you know, the independent thinking of the justices there. There are a lot of issues that the Supreme Court could take up at the first instance and doesn't, whether that's intentional or just because, like other judges, even though they might have a little more time than the trial court here, they've got busy dockets and lots of issues to discuss. And I think it's important. Our Tennessee Supreme Court has recently clarified, I think in the State versus DeBerry case, that appellate courts oughtn't go out of their way to decide issues that aren't presented by the parties, and that issue certainly wasn't presented by the parties here. And there's also longstanding precedent that we shouldn't be reading into Supreme Court opinions what's not addressed. They stand for the propositions that they address in their opinions. They hold what they hold, but we're not to draw inferences about what is or isn't addressed as some sort of binding, controlling decision on issues that aren't presented. The cases where the issue has been presented, the Supreme Court and the Court of Appeals in binding decisions has held that the Declaratory Judgment Act doesn't expand the jurisdiction of the Chancery Court to embrace the criminal realm that it wouldn't otherwise have any jurisdiction to interpret or declare.
So the Clinton Books case that the plaintiff's referencing you're talking about, that was a Supreme Court case?
It was, Your Honor.
Did it go directly from the trial court to the Supreme Court, or did it also have to go through the Court of Appeals and then to the Supreme Court and then be remanded to the Chancery Court?
It hit the Court of Appeals in between as well.
Okay. Go ahead.
Your Honor, the other cases that the plaintiffs rely on are unpublished decisions from the Court of Appeals, namely the Blackwell decision. Carter, which we've cited, postdates Blackwell, which the Court of Appeals undermines significantly. I think tracks the arguments that we've made. The decision in Blackwell versus Haslam, and you know, without rehashing the arguments there, I just point Your Honors again to the fact that Spoon, Zirkle, Hill, Memphis bonding, all of those are published decisions by the Tennessee Supreme Court or the Court of Appeals. They're binding on this court. Blackwell is an unpublished decision. It's contradicted by the later decision in Carter. Both of those are unpublished. To the extent that those wash out, you know, we'd suggest that Carter is better reasoned and it's the later in time. But if those wash out, we're still left with the published authority in Memphis bonding and Spoon and the other cases that we've relied on. We think that's what ought to control this court's decision here. Given that, we think that's
notwithstanding the arguments that General Groves has made, that's the easiest way for this court to resolve this matter, is to simply hold that it lacks jurisdiction to grant a declaratory judgment to the plaintiffs over the applicability and constitutionality of criminal laws and enter judgment for all of the state defendants.
Well, should we dismiss the case if we find we don't have jurisdiction, or should we transfer it?
I think, Your Honor, there is a statute that allows for transfer. I think at this stage of the proceedings, it'd be appropriate to dismiss it for lack of jurisdiction. The plaintiffs could, refile at that point. It's not a request that's been made from the plaintiffs at this point to transfer to another venue, but there are statutory procedures for that to happen.
All right.
So beyond, again, having the wrong challenge in the wrong court, plaintiffs also have some of the wrong defendants here. Now, we've not disputed, as Mr. Harris has said, that the commissioners, the district attorney general, and of course we don't represent the sheriff, we've not disputed that some of those state defendants are properly parties to the suit. We of course contest that there's any entitlement to judgment against them. But we do preserve that General Scarametti and Governor Lee are not proper defendants. And it's important here, the question at summary judgment for your honors to consider is different than the one at the motion to dismiss stage. And I think the Moses versus Goins decision that we attached as Exhibit 4 to the summary judgment motion is very illustrative of this point. At the motion to dismiss stage, all a plaintiff has to do is make allegations in the complaint that raise a claim to the level of plausibility. They get standing at that easy standard at the motion to dismiss stage. We take everything as true and see if they proved up their case, could they possibly be entitled to judgment against the defendants. Now we're at the summary judgment stage where plaintiffs have the burden of proof to prove that they're entitled to a judgment against the governor of the state and the attorney general of the state that declares that the governor and the attorney general are violating Tennesseans' constitutional rights. That's an extraordinary remedy, and it's one that is not supported by any of the proof. So we stand by our arguments in the motion to dismiss that General Scarametti and Governor Lee should never have been parties to this case. But we have a different question here at summary judgment as to whether the plaintiffs are entitled to a judgment against them after litigating the case. And so it's important to look at the proof that's been provided here, and there really is none. We'll talk first about General Scarametti. There is nothing in the record that fairly traces plaintiff's alleged injury to General Scarametti. That's the second prong of that three-part standing analysis. There's no proof that General Scarametti prosecutes or intends to prosecute any of the plaintiffs. He can't because he's not a prosecutor in this state. There's no proof of coercive directives to prosecute. Other courts have considered whether a government official can, coerce subordinate officials into undertaking prosecutions. That's not our system of government in Tennessee. District attorneys general are elected independently. They're not answerable to the attorney general. So the attorney general can't coercively direct DAs to prosecute. And there's no proof that any law enforcement has even relied on the AG interpretations that plaintiffs offer as the only connection of General Scarametti to these things here. And we did this in the motion to dismiss. I'll again direct your honor's attention to the Sixth Circuit case, Universal Life Church versus Neighbors, which addressed a very similar situation where claims were brought against district attorneys general and the attorney general, and the Sixth Circuit held that the attorney general wasn't a proper defendant there, that you couldn't trace the enforcement action that caused the alleged injury to the attorney general. Secondarily to that, plaintiffs have also relied on the Declaratory Judgment Act as justifying inclusion of General Scarametti as a party in this case. We dealt with that a lot in the motion to dismiss, and your honors have just ruled on that motion to dismiss that the Declaratory Judgment Act made General Scarametti a proper party, someone who could be joined to the action. But again, at the summary judgment stage, we have a much different standard. The question is whether the plaintiffs are entitled to a judgment against General Scarametti in this case. The again, the plaintiffs have not introduced any proof that General Scarametti is liable and ought to be adjudged liable for their allegedly imminent injuries. They cannot obtain judgment. Even if you accept, as the court did in the ruling on the motion to dismiss, Cummings versus Beeler as controlling Supreme Court precedent, that precedent would only govern whether the AG is a properly named defendant. It says nothing about requiring that this court enter judgment against the Attorney General when there's no proof that the Attorney General is responsible for those injuries. And to take it out of the abstract into the practical here, I'd ask your honors to consider the consequences of adopting plaintiff's position. If we go with their theory that the AG opinions, which are non-binding, non-precedential opinions from the Attorney General's office that are interpretive aids for officials across the state and for the courts, that is enough that plaintiffs are entitled to a declaratory judgment against General Scarametti that he has violated constitutional rights. The appellate judges of the state, perhaps even the trial court judges of the Tennessee Supreme Court, go a lot farther than non-binding interpretive aids for state officials. They interpret the statutes authoritatively, say what they mean and how they ought to be applied. So if the connection between Attorney General and the alleged injury here is enough, the justices of the Tennessee Supreme Court, the judges of the Court of Appeals, the Court of Criminal Appeals, perhaps even your honors, are proper defendants, and plaintiffs are entitled to have judgment against you in the next lawsuit that comes down the road. I'd also point out that the Declaratory Judgment Act's purpose in providing the Attorney General notice and an opportunity to be heard applies in all sorts of different proceedings that sometimes look different than ones like this. Here we have a challenge to a state statute with other state official defendants, but the Attorney General, we've cited a number of opinions in our briefs, has been party to divorce proceedings, contract disputes, defamation suits. So if, as plaintiffs argue, it's all just fine that the Attorney General is made a party and judgment enters against him because the Declaratory Judgment Act says he needs to have a notice and opportunity to be heard, that means the next time Jones v. Jones comes around in a divorce proceeding and there's a constitutional challenge, Mr. Jones is also getting divorced from General Scarametti because the judgment in that case has to enter against him. Or the contract dispute between, Acme Consulting versus Smith Feed Company, and a breach of contract action where there's some constitutional challenge to a statute that's involved there and the Attorney General intervenes or is named as a party, there's judgment against the general in those other actions. And that's an absurd reading of the Declaratory Judgment Act, certainly not anything that's required by the text, and it's nothing that's required by precedent. Even if we take Cummings versus Beeler as continuing to be good law and binding this court on its decision in the motion to dismiss, it says nothing about whether judgment ought to be entered against the Attorney General. I turn next to Governor Lee, and here the case is even easier. The only allegation that plaintiffs have made to justify Governor Lee's inclusion in this case is that he has the ability to hire and fire commissioners. They've not introduced any proof that he has hired or fired commissioners or given directives to the commissioners that if they don't enforce these statutes in a particular way, that they're going to be fired. So they haven't even proved that causation theory, again, on that second element of standing. But for a number of reasons, I direct your honor's attention without relitigating stuff that's gone on in the motion to dismiss. The Doe versus Lee case decided by the Sixth Circuit after this court decided the motion to dismiss, and the NAACP versus Lee case, which is a federal three-judge panel case, decided again after this court's decision on the motion to dismiss, are both directly on point here, offer ample support to the defendant's position, and warrant, again, this court reaching the conclusion that, despite its ruling at the motion to dismiss, that plaintiffs are not entitled to a judgment against the governor of the state and the attorney general of the state, saying that they have violated or are imminently about to violate plaintiffs' constitutional rights. turning finally to the third issue, plaintiffs have asked for the wrong relief from this court. And this is connected a bit to the arguments that General Groves has made about the nature of the facial challenge, but plaintiffs cannot obtain a judgment on behalf of non-parties. We think there's all sorts of reasons to deny a declaratory judgment before you ever start looking at the scope of relief. But if this court's in the position to be looking at those issues, the judgment that they ask for is unattainable by these parties in this posture. The court cannot take an eraser to the code book and just wipe out sections of statute. Facial challenges are broad. It's a strong medicine, strong remedy, and there's strong reasons why this court shouldn't employ a facial challenge that General Groves has discussed. But even facial challenges are judgments that apply in favor of the plaintiffs of the case against defendants in the case. So even a facial challenge win for these plaintiffs is a win for these plaintiffs against these defendants, and the court should resist plaintiffs' invitation to go further to exceed its jurisdiction and take an eraser to the code book and grant relief to people that are not parties in this case, or relief against individuals that are not parties in this case. For those reasons, Your Honor, again, in addition to the reasons that General Groves discussed on the merits, we think the state defendants are entitled to summary judgment. We think the declaratory judgment issue, the jurisdiction of this court, is a threshold question, and it's the easiest way to dispose of this case, to follow the longstanding precedent, published precedent of the Tennessee Supreme Court and the Court of Appeals. This court should hesitate immensely before entering a declaratory judgment saying that the governor or the attorney general have violated plaintiffs' constitutional rights, and this court shouldn't need to reach the issue, but if it does, it should refrain from entering relief that goes beyond the parties to this case.
All right, Mr. Brandon, are you aware of any Tennessee case, Court of Appeals, Supreme Court, or anything in which a final judgment was entered against a sitting governor, whether it be Lee, Haslam, Sundquist, McWhorter, whoever? Has there ever, in the history of the state of Tennessee, been a final judgment entered against a governor in his official capacity?
I believe there has, Your Honor. I don't have one off the top of my head, but
How did those plaintiffs get to the point that they got a judgment against our governor in his official capacity?
Yes, sir. I'd have to look back at the cases, Your Honor. Sometimes the arguments that we're making today just aren't raised, and so that could certainly let that happen, let that transpire. I guess the Blackwell versus Haslam case would be one of those examples where the governor was a named defendant there. That's a case that went up on final judgment to the Court of Appeals, and that dealt with the declaratory judgment issue that we've raised, but not anything about the standing concerns we asserted here. And there is a possibility that judgments could be entered against the governor or against the attorney general in specific circumstances. And I direct your honors again to the Moses versus Goins decision, which was a decision of another 3-judge panel in Shelby County, where they, again, were looking at the motion to dismiss standard. They held that based on the bare allegations of the complaint, the plaintiff there had alleged that the attorney general denied the plaintiff their right to vote, denied their voter registration. Now, that was a suspect allegation because the attorney general has nothing to do with registration and doesn't have enforcement there. But the court there noted, we take the allegation at face value, but what you're going to have to do is prove that when you get to summary judgment. You have to prove it through later proceedings. And so if there was a world where the plaintiffs there had proved that the attorney general did in fact deny their voter registration, you could get to judgment against the attorney general in those circumstances. So there are cases where that could happen. This is just not the one.
Okay, so I think you may have answered my next question. My follow-up is going to be, are you aware of any Tennessee case, Court of Appeals, Supreme Court, where there was a judgment entered against our attorney general? And at any time since the attorney general was instituted, are you aware of any judgments being entered against the attorney general in his official capacity? And if so, how did the plaintiffs get there?
I know I'm not familiar with the procedural aspects of the case. I know General Scarametti was a named defendant at the case that recently went to the Supreme Court over the gender transition surgeries ultimately, of course, we were successful, or we hope to be successful. We don't have a decision there. We were successful at the appellate court stage there. So that's not a final judgment. Again, I don't know that those arguments were particularly raised that we're raising here. So I don't know that I can answer
But the
your
general's
question.
still a party through the trial court and the Court of Appeals level, and now he's still a party defendant at the Supreme Court level.
He is, Your Honor.
Okay. Judge Burke?
I don't have anything.
Judge Rice?
No, thank you.
All right, thank you, Mr. Brandon.
The state raises three issues in this, and I think all three of them are really revisiting decisions this court's already made in either the August of 23 or the March of 24 decisions. So we're replowing ground perhaps to preserve the issue for appeal. But the first is the wrong court argument. We've got two statutes we brought the action under. One is the relatively recent statute 1-3-121, which allows any affected party to seek a declaratory or injunctive. So you don't have to seek both. You can seek either or. We filed initially for both. Injunction's been excluded from the case at this point, but we still wanted to proceed on declaratory relief. And clearly 1-3-121 allows that. Similarly, the three-judge panel statute 20-18-101 allows for a constitutional challenge seeking declaratory or injunctive relief to proceed in front of a three-judge panel. This was the issue that the court addressed, I believe, in the March of 24 opinion, where it already found, dropped in a footnote 6, I believe, that said, while we don't think we have injunctive relief because the case is styled in Chancery Court, we do believe we have declaratory relief. I think the court's properly decided both of those cases, or that issue in terms of can we proceed in this court for declaratory relief on the singular questions of are the challenged statutes unconstitutional? It's important, I think, to keep in mind we're not asking for a money judgment. We're not asking for injunctive relief against the governor or any of the other defendants. We're seeking a declaratory ruling under those two statutes that a particular government action, the enactment of two challenged statutes, are unconstitutional. I think both Clinton Books and the Blackwell versus Haslam cases do support that. Blackwell was a case I was involved with David Rabin, where the gentleman had received a pardon from the state of Georgia, moved to Tennessee, tried to apply for a handgun permit, was told that Tennessee did not have to recognize the Georgia pardon under the full faith and credit doctrine because it violated the public policy. That was directly against Governor Haslam. It went to the Court of Appeals twice. The case was never dismissed on claims that the Chancery Court lacked subject matter jurisdiction. So it did go forward. I think, Judge Mansfield, you've raised an interesting question. We've all proceeded in this case, at least the litigants, based upon the court's prior two rulings, in particular the one that said, hey, we do have jurisdiction based on particularly the three-judge panel statute, if I read the order correctly, to decide the declaratory judgment issue. Oddly enough, I've asked my paralegal to help me research this question of, since the three-judge panel process is so unique, what happens if you move for a transfer? Do you
Just get a new panel?
do you get a new panel? Do you get a new judge? Does the case get transferred from Gibson to one of the other counties? Because there's nothing in the statute that would say if we filed it in one of the other counties with a circuit judge that Chancellor Mansfield couldn't be part of the panel. There's nothing that precludes chancellors from serving. It's just sort of quirk where the three-judge panel statute really, I think, was poorly written. And it begs for some either legislative or judicial insight, but it's where we are. I do think, given the amount of time, effort, and resources that the parties have spent, just dismissing the case based on that issue is probably not correct. I'm not exactly sure, though, how transfer works, other than there could be a transfer order, perhaps to circuit court in Gibson County. Makes more sense to transfer it to circuit court in one of the counties where the panel judges are already sitting. That way, there's really no need for substitution of panel members. I will say, though, I've recently filed a case against the city of Memphis over the charter amendments that they adopted in November. Curiously, based on this case and the March ruling, I filed it in circuit court. And the circuit judges in Memphis have ruled, we don't have jurisdiction. They transferred it to Chancery. So I'm at a loss sometimes of who has jurisdiction over just the simple constitutional question of, is a statute enacted by the state in violation of either the state or the federal constitution? Wrong defendants. I mean, clearly, this is not a grounds for dismissing the case. At most, it's an argument still renewed from the motion to dismiss decided in August of 23 that Governor Lee and Attorney General's committee aren't proper parties. As to Attorney General's committee, the court's already ruled on that. It already ruled on both of them. There's a Tennessee Supreme Court decision, Beeler. This court chose to follow it. The AG apparently doesn't like it, but it's still a Supreme Court decision that has not been vacated. And I think it does clearly say that the Attorney General in a constitutional challenge is a proper part. They have to receive notice, but they are still a proper party, and I think Beeler even says a necessary party to litigation that's bringing a constitutional challenge against the validity of a state statute. Then as to, and I want to make clear, because, and maybe it's just the way I heard the argument, we're not seeking some kind of monetary judgment. I mean, 121 clearly says I can't ask for money when we bring a deck action. So there's no monetary judgment being sought against Scarametti or Lee. There is no claim being asserted that either of them in their official capacities have engaged in unconstitutional conduct. I mean, the case law is pretty clear that in order to bring an action against the state, and the record reflects, when we did the first amended complaint, we named the state individually or as an entity as a co-defendant and ended up dismissing it out because the Attorney General's office brought sufficient arguments to say that, hey, you can't sue the state. You have to sue an official. And if you remember at oral argument back before the August of 23 decision, when we were in the Chancery Court in Gibson, we had this brief discussion that, and I think the Attorney General's office agreed, that if you don't sue the governor and or the Attorney General, a high-ranking state official, that the only way to get a declaratory ruling that would have statewide effect is you'd have to sue every commissioner, every DA, every chief of police. You would have 100 or so co-defendants in a case, and that's unmanageable, and I submit unnecessary if what you're seeking is a declaratory ruling that a particular statute or statute is unconstitutional.
Hey, Mr. Harris, this may be a question better suited for Mr. Brandon, but I've always wondered this. You know, I'm a chancellor, so I deal with civil matters, all right? But in every criminal matter, it's the state of Tennessee versus so-and-so. So why can the state be on every criminal docket and every criminal jacket that goes through the state and all the Supreme Court, Court of Criminal Appeals and all that, but they can't be sued in a civil court? Or what is the state of Tennessee in the criminal context that makes it different than the state of Tennessee in the civil context?
Essentially, they can only be plaintiffs and they can't be defendants. and I don't know that there's a good answer to that. I think that it makes no sense. But
Is there a statute that does that? But it's because there apparently is an entity known as the state of Tennessee that prosecutes criminal actions. And so is there a statute or a constitutional provision or what prevents the state from being that same entity that prosecutes criminal cases? What prevents that from being a defendant? You said they can only be plaintiffs. Why? What is it that prevents them from being a defendant?
Yeah, you know, that's why when we did the First Amendment complaint, we tried to name them because, frankly, it seems simpler to me if you could sue the state in a declaratory judgment action as the entity. You wouldn't need to name all these other individuals. And the Attorney General's office, which was forceful, and I just didn't think it needed to be litigated, was that, no, you can't, that there's apparently case law that says you can't directly sue the state. But I'll submit to
I said that, this might be a better question for Mr. Brandon, but I've just been curious, and really, that's a curiosity thing.
Oh, yeah, I would much prefer to have seen Hughes versus State of Tennessee, because I see State of Tennessee as a party in all kind of stuff, but apparently not in declaratory judgment actions on the constitutionality of criminal statute.
Okay. Thank you.
But I do want to make clear is to the extent I understood his argument to be that we couldn't get a judgment, what we're seeking is only a declaratory ruling that these challenge statutes are unconstitutional. And whether that's as to one defendant or all defendants, we're still seeking that declaratory ruling. And because of Haslam and the cases that we cited previously and that we argued previously, I do think it's appropriate to include them. And then I'm not sure, because this is relatively new on this issue of whether or not we can obtain a judgment on behalf of non-parties. I mean, in this case, we've got 3 named individuals that are asking for declaratory ruling. We've got 2 representative plaintiffs, Gun Owners of America and Gun Owners Foundation. I don't recall, because I picked it up and looked at it, I'm used to being in federal court in situations where federal judges issue nationwide injunctions, that protect everybody, usually when they make a ruling that some statute or federal reg is unconstitutional or illegally adopted. I don't see in our complaint that we've asked for a statewide injunction. Since we're not seeking one at this point, we're merely asking for the court to declare that these 2 challenge statutes are unconstitutional. And then whatever effect that has, whatever use we make of it, is sufficient. And I will give you, for example, should the court rule that one or both statutes are unconstitutional for purposes of Federal Civil Rights Act, that puts the state and all government officials on notice that the attempt to enforce that would constitute a federal civil rights violation, just like what happened in Beeler. And so we don't need a declaratory ruling that somehow seeks to protect, like an injunction would, non-parties. Declaratory rulings don't implicate necessarily, in this context, non-parties. It's just a declaration under 121 that the government action is constitutional or not. And if there are questions, I'll be glad to try to answer them. If not,
Judge Burke?
I don't have any questions.
Judge Rice?
thank you.
Thank you.
Thank you, Mr. Harris.
Thank you.
Mr. Brandon?
Just very quickly, Your Honors, on this case being in the wrong court and the jurisdiction to enter a declaratory judgment, 13121 and the 3-judge panel statute don't change anything about a chancery court's decision. They don't do anything to affect the long-standing law and restrictions on a chancery court's jurisdiction. 13121, according to the Tennessee Supreme Court in the McNary County case, simply provided a cause of action that could circumvent and waive sovereign immunity for certain actions, where before the case that Mr. Harris and the plaintiffs have brought today would have been dismissed at the outset because there was no cause of action to vindicate state constitutional rights in a pre-enforcement challenge that could only be vindicated in post-enforcement defenses of criminal proceedings. That's the purpose of 13121. It doesn't alter anything about the Chancery Court's jurisdiction or say where those claims ought to be brought. And the 3-judge panel statute also doesn't alter anything about the Chancery Court's jurisdiction. What it says is that when a claim that challenges the constitutionality of a state statute when brought against state officials is brought in any court, circuit court, Chancery Court, criminal court, 2 other judges are going to be added to that case and made a part of that court to decide the case. And it's the job of those 3 judges to hear and determine the case. This court here can hear and determine that it doesn't have jurisdiction as a chancery court to declare the applicability or constitutionality of state statutes. For those reasons, and again, all the reasons we've made in General Gross's argument and my opening argument here, we believe the state defendants are entitled to summary judgment.
All right, same question for you I asked Mr. Harris. So what's the deal with the state of Tennessee being a party in all these criminal cases? And I see the state of Tennessee at various places in the code or in cases and that I read in the reporters. And why can't the state of Tennessee be sued in this case?
I think there's two related doctrines that explain why you see the nomenclature there. So it's a matter of both sovereign immunity and standing. And we've also got, tradition and directives from the legislature in terms of when the state itself as a whole organizational entity is a party. So, for example, in the criminal context, you've got the state of Tennessee that's moving affirmatively against a defendant with the weight of the people of the state. You'll see in many other states the prosecutions are brought, the people versus whatever. And that's an indication that the state as an entity in all of its facets is moving against this individual defendant in that criminal proceeding. There's no sovereign immunity for the state there. You're not talking about standing. The state's taking action in that proceeding. You have similar authorizations in particular statutory proceedings. So, for example, under our consumer protection statutes, in a similar manner, the state as a plaintiff and moves affirmatively against individuals in civil proceedings. There's certain, I believe, in quo warranto proceedings that are brought in the name of the state, even if they're prosecuted by relators, because it's seen as an action of the people of the state as in its entire entity. In those contexts, we don't have sovereign immunity or standing issues where, in the defensive context, you have to show that the state as an entity in this abstract, as a conglomeration of all the people, is responsible for your constitutional violations or whatever it might be. There are situations where the state is a defendant. The General Assembly has dictated that in the Claims Commission for claims against the state that fall under particular definitions, it's the state which the General Assembly waives sovereign immunity for with certain statutory caps and creates this proceeding is the proper defendant there. So there are places in the landscape where the General Assembly has specifically altered what might be the normal relation and the default that the state as an entity isn't normally a party to proceedings, but we don't have any of those alterations here.
The king has not yet consented to be sued, is what you're saying.
I think that boils down to it, Your Honor.
I understand. All right, Judge Burke?
I don't have any further questions.
Judge Rice?
No, thank you.
All right, thank you, Mr. Brandon.
Thank you, Your Honors.
All right. I'd like to thank you all for being here today. This is certainly enlightening, and enjoyed having you here. And thank you to our hosts. I really appreciate the courtroom being made available. Officer, thank you for being here today. So we will take this under advisement, get you guys a ruling as soon as we possibly can. Anything else that we need to talk about before we adjourn, Mr. Harris?
No, sir.
Okay. Mr. Brandon? All right, there is one issue. Is there an intention on either party's part to type up this transcript anytime soon for?
I expect we'll order a copy of the transcript if Your Honor would like for us to provide that. I don't know if that's what Your Honor.
That's where I was headed. I was going to see if anybody was going to order that, and if they were, if the court was going to request a copy of it. So.
We're happy to provide that as soon as we get it. We can file it. Would Your Honor like it in the case file?
That'll be fine. Electronic copy will be fine. No need to make additional copies out of it. So. All right. Good deal. Anything else, judges, we need to talk about?
I don't think so.
All right. Thank you, everybody. Glad you were here today, and I hope you have a great week and a safe trip home. And as of now, we are adjourned.